So Josh, I will let you have it.
Thanks, Cody. Hi, everybody. So we'll go ahead and get started. I'm glad everybody's here. A couple of things that I sort of always like to talk about is I really love agenda, partly because that keeps me on track, but that also keeps all of us on track. I have sort of split this up into a few different kind of sections and trying to give everybody sort of a 5 minute break. I know how these kind of 5 minute break kind of in between sections. I do uh, like to kind of flow through sort of the history of copyright as we're kind of talking through it because it sort of sets us up for understanding kind of the major issues that we might have to deal with when we're dealing with copyright. Another thing that I kind of want to mention, lunch is a little early for everyone on Central Time. It's actually 11. Apologies for that. I'm kind of trying to like line up lunch schedules for myself and my partner and everybody else and what makes the most sense as we're trying to go through here. If you didn't know, I'm actually presenting from Atlanta, Georgia, so I'm an hour ahead of y'all here. So we can see our kind of breakdown. We will have little slides that'll talk about for when our breaks are going to happen, so you'll see them come up, and we'll go from there. I did promise case studies. I only really thought through one of the case studies I have, and we're going to do that, but we are going to have a lot of opportunity for discussion, even kind of during lunch if you would like, so we can kind of have a little bit of a lunch-based discussion as everybody's sort of doing what they need to do to get their sustenance. A couple of notes here. I am not a lawyer. I cannot give anybody legal advice. So everything I'm telling you here is from my own experience, from my work, from my research, and kind of everything along that. For the most part, I do have strong opinions about copyright, and I can sometimes say that maybe legal precedent doesn't always support some of my strong opinions on copyright, but we can get to that as we're working through our workshop today. But I just want to let you know, like you cannot take anything I say as legal advice, and do not say, "Well, Josh said do this." In a court of law at any point in time because I'm not giving you legal advice. Now, I can say, uh, since I've worked so much with digital collections, with institutional repositories, I have become intimately familiar with copyright. At first, it was sort of nobody was doing it in the library when I was at Georgia College. And so I kind of jumped in and started helping us figure out what our copyright issues were. And honestly, I answered so many faculty responses about copyright that I just kind of became the de facto copyright person, and then kind of just became one of my favorite things to teach when I was at Clayton State, was specifically the law course. And copyright's fun, but also privacy rights really fun too. So that's always a good one to chit chat about. I've taught this course for SAA. There is a law course related to digital collections that if you've ever done the DAS and taken that online course, you've heard my voice. So hopefully you won't be annoyed by my voice today. Couple of quick things I want to talk about our goals. We are probably not going to be able to cover every single scenario related to copyright in 4 hours. And that's okay. We're here to start a kind of basic conversation about copyright and to allow us to be able to talk and discuss as a group, because I've got some opportunities for sort of a discussion as a group. Of course, if you don't feel comfortable talking out loud, that's okay. That's what we have a chat box for. I'll kind of talk about how I like to flow the workshop in just a moment. I also want to kind of, at least I will say this to kind of set the sort of the stage for this. From my perspective, and I think I have a lot of backing, kind of just judging from the sort of legal environment around copyright, is sort of discuss the way copyright sort of is administered in the US and the way it's kind of understood, especially by the courts and to some extent by legislators. And then, of course, my last sort of goal for this workshop is I really want you to think about all your copyright and collecting policies. Both this, you should think about this from collecting, so deeds of gifts or donor agreements, access and how that's related to copyright, and use, specifically around this idea of making the ability to use and our ability to collect more equitable, regardless of the groups we are dealing with. And I'll kind of explain that as we go throughout the day as well. You're probably starting to see some of my strong opinions on copyright starting to flow through just a little bit here. In terms of how I want the workshop to flow, this is kind of my sort of framework anytime I do any kind of workshop is, first and foremost, ask a question in the moment. I think it's really important, especially for copyright, to and since this is a live workshop, it's better to ask those questions right then and there. So raise your hands or post in chat. My colleagues here from the PDC are going to read those questions out loud so it can be captured in the recording. Another thing I kind of ask for everybody to do is be respectful. Everybody, I assume, in this workshop is coming from sort of different environments, different types of archives, different perspectives, maybe even different amount of experience having to deal with these sort of complex copyright questions. One other thing I also like to mention is, as we're kind of discussing copyright, sometimes it's really important for us to get out of our framework as archivists and what's necessarily best for us as archivists when it comes in terms of copyright. And so when we think about these issues related to copyright, especially for collections we are collecting, we need to think about and put ourselves in the mind of the person who is donating those materials and how they may have various types of connections. These could be emotional, they could be financial, or they could be kind of this sort of cultural connection, which oftentimes when I think about those sort of cultural connections, they are important, but maybe not something the law always acknowledges. Of course, also researchers have similar types of connections when they are doing research. And I think it's really important to not always be in that sort of archives first mindset, but be in a sort of mindset that encourages us to think about all of our constituents when we're working with collections. So before we start jumping into content, any questions from anybody? If it's okay, I know sometimes I'll let everybody do introductions, but I know that can get a little bit old, especially when we have a big group. So I think I'll forego kind of introduction. So if you ask a question, if you want to introduce yourself really, really briefly, then I think that will be fine. And another sort of small workflow thing that I'll do is, so if I ask a question or ask if there are any questions, I usually do like a 30 count. And if I don't see anybody typing or I don't see a hand get raised in Zoom, I will probably move on unless I think that maybe people are thinking a little bit. So usually if you see me pause as well, that's me waiting to make sure everybody's thought marinated on different kinds of questions too. Of course, we have a number of breaks, so hopefully we will be able to, if we don't get to a question in a moment, then we can also get to them when we have our little breaks. All right, so everybody strap in. It's gonna be 4 hours. So our first sort of section is, I call, and apologies, I sort of feel bad that I made animal themes for each one of these topics, but it helps me flow through things a little bit, so forgive me for that. But we're talking about Luis Lama and their useful art. So basically, this section we want to talk through issues around copyright history, sort of roughly. There's a lot of things we could dive into in the 19th century, but really most of what we're dealing with a lot is the sort of 20th century kind of archival issues that have popped up. So let's talk a little bit briefly about the origins of copyright. So in terms of kind of when we're dealing with copyright, and I think this is one of the key things to understand about anything we're dealing with when it's a legal environment in archives, is there's actually several layers of law. The sort of first layer of law is, I always call it like the black letter law or statutory law, and that is the actual pieces of legislations that have been enacted by whatever legislative body, whether that be state, local, federal, that concerns whatever the topic is. And for copyright, as you can see, there's sort of been a number of different acts. The first one that came about was the Copyright Act of 1790. And I think this is sort of the trend I want you to notice is like notice the trend on the duration of copyright. So our first Copyright Act allowed for 14 years. Then you could renew. So basically you got 28 years total for your copyright. Second kind of major Copyright Act was the Copyright Act of 1909. That gave you 28 years with one renewal, so 56 years. I always like to say I was tenured in the math college, but doesn't mean I'm good at math. Next kind of major Copyright Act, and the one that we are mostly dealing with here, although there's a couple other ones we'll talk about in a minute, is the Copyright Act of 1976 that extended, that sort of changed from this requirement to do renewals and register to kind of like automatic copyright and related more directly to the author or the creator of the materials. Big thing that came about with the copyright statute in 1976, of course, is we get this idea of various exemptions and our kind of fair use statuses that we have in copyright. So, and also I should also mention too that our statuses too for kind of libraries making reproductions came about in the 1976 copyright. There are, of course, a number of other major ones that have popped up in the last few years that kind of start giving us some consternation. We talked a little bit about 76 copyright. What really helped, I think, really to keep in mind too is 76 actually ended copyright for unpublished works or perpetual copyright. So there is sort of a time frame and a time limit. The other sort of major Copyright Act was the Copyright Extension Act of 1998. Interesting enough, this extended terms for all copyrights from it originally was the life of the author plus 70 years or 95 years from publication for hired work. That became 115 years or 90 years there. It did kind of add some slight mitigation for related to those our ability to make copies, but doesn't really fix a lot of the modern problems we have with making copies for preservation or access purposes. Funny note, the Sonny Bono Act of 1998 was really expressly written for a lot of the major corporations, Disney in particular, because their copyrights were going to be ending pretty soon around that time frame. And guess what? The copyright for specifically Mickey Mouse just ended, or the original Mickey Mouse, Steamboat Willie, ended this year, directly related to this Copyright Extension Act of 1998. So fun note. We also have the Digital Millennium Copyright Act, which is really related to sharing copywritten materials online. I'll talk a little bit about kind of what some of that means in just a moment. And then the one that I still don't think they have quite figured out how it's going to work is the Music Modernization Act, which is directly related to applying copyrights to pre-1972 audio recordings, because those sort of weren't covered explicitly under the 1976 Act. So basically, it's that term is anything before 1923 or in December 31st, 2001. That's actually, that's probably wrong. So 1923 through 1946, that's 5 years plus 95 from publication. So it extends that term out. 47 to 56 is 15 years plus 95 from publication. And it fixes basically anything before 1972 it allows that to have the copyright till 2067. And the initial idea for this was that a lot of musicians who had created copywritten works that predate that 72 weren't able to kind of monetize some of their work from that period. This also created a whole system where you're supposed to request permissions for music through a specific commission, and that sort of kind of never really gotten off the ground. It's supposed to be a mix of like the Copyright Office and the music industry. It's sort of, I've been kind of looking this as a sort of a wait and see to see what kind of it happens and does, but we'll talk about music in a moment. So one of the things I always like to pause for and to give us a moment with after we kind of talk about some of the legislative is sort of that constitutional mandate for copyright. And I'll read this out loud, and then I kind of want to give us a moment to pause and maybe make some comments on what you think about this. So mention these laws, which is sort of a kind of way to think about what the Constitution, U.S. Constitution, says about copyright. So we're in Article 1, Section 8, says Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discovery. Of course, I've bolded things here to draw your attention, but what is your response when you see the original sort of constitutional mandate for copyright? And if someone wants to raise your hand and talk, or if you want to throw some things in chat, please do. So there's the promotion. Dennis talks about this idea of creation and promote creation and innovation. Some other thoughts. Some personal gain. There's sort of this idea they acknowledge that people doing this kind of work deserve to get something out of the work they've done for a time. It's not intended to be forever, thanks to Shannon. And I should acknowledge Susan came up with our idea about personal gain for some time. Anything else? Like, well, there's one more thing I don't think anybody has brought up. To some extent, the one thing I really wanted everybody, and Susan mentioned this, mentioned government regulation, is this idea of exclusive right. And that means, yeah, exclusive to the creators here. The idea is that they have certain things that they are allowed to do. And we're going to, of course, get into what that means a little bit too. But I really sort of draw out, I think, one, of course, we're going to talk about sort of all of the sort of issues around intellectual property as a whole in just a moment, because I think it's good to place copyright in that context and understand what all's being done in terms of intellectual property. It's really about encouraging people to make new stuff, useful stuff, ideally. That's really related to patents and such. But it's really, I always go back to this limited times, and it's really to not discourage people from, I think, remixing, thinking about it, using stuff, and trying to do new things with stuff that's already been around. That's sort of my perspective here. So when I say it is the talk about sort of the constitutional purpose, I like to reference back to Sandra Day O'Connor in Feist versus Ruled Telephone. This idea specifically around this compilation of publicly available materials. But O'Connor's sort of remark here is that the essence of copyright, the primary objective of copyright is not to reward the labor of authors, but to promote the progress and science of useful arts. And I really like that sort of visioning of copyright, although we could probably talk about how some more modern, I think, cases have maybe redirected that a little bit. But I can take the assumptions I think we want to take away from here is that authors are going to do stuff because they want to make money. Okay. Or people tend to do stuff, not always. The idea around our statutory limitations and requirements is that we're trying to balance what the public needs are versus, the ability to make private gains and to ensure your work can benefit yourself. One sort of, I think, nuance I like to mention here is that while we're talking about copyrights as an intellectual property right, it is still a property right. And what I mean by that is it's oftentimes transferred around, and that's where I think things get a little bit problematic. That copyright doesn't always stay with the person who originally created it and kind of goes out and kind of becomes something else that somebody is using that they may have not put any labor into, but have definitely put some financial resources into. I think that's a nice way of saying it, but they themselves are not the person who created it. So I kind of like to think about that as an issue we want to engage with a little bit. So I kind of bringing us back, and I mentioned that we would talk about this, is that copyright is really enmeshed in the whole concept of intellectual property in the United States. And this is sort of protections for creators and inventors. And copyrights really, or intellectual property is really three different things from a US perspective. That's patents, trademarks, copyright. So patents are things, tangible things, something that somebody has created, although it's gotten a little more complicated in modern American kind of patents. Trademarks are names or symbols, which is still an intellectual property. And then copyright is written and artistic expression. Of course, things all get a little wonky here and there, but we'll talk about this. So let's talk a little bit too, before we talk about the specific issues. There is a slight international perspective. The US has always been a little weird about getting onto international conventions, especially around copyright. There's been a lot of intense effort to try to get other countries to sort of respect US-based copyright too. But the Berne Convention does allow for the protection of literary and, more importantly, artistic works. Specifically, our laws have now kind of been harmonized with international law, and of course, the Berne Convention also doesn't force us to have those sort of formalities of notice and registration. Really, the big takeaway here is sort of the good thing I think about modern copyright law is once you write something, then you own that product. Even my really bad, freshman year paper that got a C on it, I own the copyright to that C level paper. Even though it was awful, but I still own the copyright. So the way our statutes work, all the different ones, they are usually administered federally. And the way it works is copyright suits are always in federal court. And usually the law that applies is whatever the federal law is for that point, or if there's been something that covers it that makes it new. Copyright itself is administered by the Copyright Office, which is under the Library of Congress. And what the statute allows to do is allow the Library of Congress Copyright Office to make what are sort of known as rules, which is sort of a secondary lawmaking process, or kind of a governmental intervention in the law. And then, of course, we also have judicial precedent, which judicial precedent ends up being the sort of interpretation of the law's intent. So kind of as I mentioned earlier, we have sort of that statutory law, which is sort of the original law as written. Then there's typically an administrative process that is used to define some of the requirements or procedures for doing that. Sometimes even have some of these rulemaking processes have the force of law to them. And then we have the interpretation of those rules, or the ability for the specific executive branch office to make those rules, and even the interpretation of the statute done through our federal judiciary. Good resource for you. And of course, I will make sure everybody gets access to these slides at the end, is just going to the Copyright Office website. They have a lot of breakdowns of all kinds of different things if you're just bored and want to read copyright stuff all day. So things kind of get weird in terms of copyright. And I would say the last couple of years has not been super kind to copyright and specifically fair use. A couple of sort of big cases specifically around art and copyright are Carew versus Prince, which is all about transformational use of images, specifically images that were taken of indigenous persons that were adapted and transformed into other works. It was considered that that particular transformation, the particular work was a transformation and therefore fair use. Of course, everyone was very concerned about the Associated Press versus Ferry or Shepard Ferry around the image of Obama. That was settled out of court, so it didn't actually create a precedent, but started to, I think, lean us into maybe sometimes transformational use is not always going to be the deciding factor. And that's where we actually find ourselves today with the Andy Warhol Foundation versus Goldsmith, which was where, Andy Warhol created that image of Prince based off of an image that a photograph of that Goldsmith took. It was determined that the new licensing that Andy Warhol Foundation did of the image that Warhol created was not transformational or fair use. Although I think in kind of defense of the Supreme Court here is because the original image that was licensed when the original image was created kind of, makes it a little more complicated. But I bring up the Warhol case saying fair use, especially around monetization and transformation, is going to be a harder sell in the court, at least now. Now, there are a couple of really neat cases that I think have made things good for governmental institutions, at least. First and foremost, there was Allen versus Cooper. Allen versus Cooper at North Carolina. Basically, the quick way to describe this is that it allowed the states to kind of be immune from copyright suits, which may or may not be good. But in this case, Allen created some videos that the state of North Carolina repurposed and reused. They had previously paid him for it. And essentially the state was immune in this case from being sued for a copyright purpose. Maybe not always a super great case for the creators, but it does give some state level kind of immunity. Of course, one of my favorite two is Georgia versus Public Resources Org, which basically said even annotated laws cannot be copyrighted. So basically allowed for, I think, an opening of government publications to be in the public domain immediately. And I think we could interpret things created by government entities to therefore not be copyrightable, whatever, regardless of state or federal. And if you didn't know, most states try to claim copyright, especially over their statutory laws and materials that they created, partly because there is some money related to it. Most of them work with LexisNexis to make these things available, and they get paid a certain amount by LexisNexis to make these things available because LexisNexis charges for it. That kind of changed things a little bit with this case, and I think that's kind of a good direction. Of course, one that I always want to bring up is Campbell versus Acuff Rough Music, which was the Two Live Crew song based off Pretty Woman that basically said that parody is allowed, and kind of started us talking about parody. And then, of course, with the Digital Millennium Copyright Act, that created a rulemaking process that allowed for the creation of exemptions to exclusive rights of creators. Things that came about this was sort of the ability to do remixes of, media content to online, jailbreaking personal phones, things like that. So kind of violating, sort of doing that kind of process, individual access to certain things that are from kind of computing and software, and a lot of other different things too. Those happen about every 7 years as the Library of Congress goes through a whole rulemaking process and then post them online. And so you can see the posts there. So I have filled your mind with a ton of legalese and legal topics and Supreme Court cases and yada, yada, yada. Let's get down to the brass tacks of kind of how some of this really works. So intellectual property. So one thing I always want you to consider when we're talking about intellectual property is think about all of these ideas and maybe make notes as we're kind of talking through them, and think about what are your archival issues in your specific organization, what might be some ethical issues and potential risk. Of course, just as a reminder, we've already talked about the intellectual property rights. Just remember science and useful arts, I think, is super important here too. So let's go through our copyrights, our patents, our trademarks and trade names. And I wanted to dump in trade secrets just so you understand what trade secrets are and kind of how that might be, in case there's anyone in a business archive that might be on this in this workshop. So quick note, and I think this is a massively important understanding for all archivists. And I've actually been having some conversations with someone about this particular issue, is that physical ownership is separated from intellectual ownership. Like, just because I own something is in my hand, just because I own any of these books I have behind me, does not mean I intellectually own them. Somebody else intellectually owns them. And I think this is a hard concept for maybe people not in an archival field, because again, I've had some conversations with some people about this particular issue, is that they think if they own it, they own it. That's not the case. You can't necessarily do, and this goes back to this concept of exclusive rights that a creator has. So let's talk about patents. Patents. So we had a remark here is the difference in ownership between informational content versus physical materials. Yeah, it's kind of to translate that, like, and we can even define this too when we talk about electronic media. Like, we might have, and if we need to talk about it actually like physical, like the CD or the install media of it, that does not give us access to the code. Or even to, and this is where things get really wonky now, especially with licensing agreement, when we download things in completely digital, that gets even more murky, where we may or may not necessarily have a long-term access to it. It all depends on the agreements we're actually making, so it actually gets more complicated. I'm kind of muddling that a little bit, but yes. And I guess I should say that when it comes to orphan works, it is different. But the thing is orphan works have a period on which they are considered where the materials may or may not be in the public domain. Still, technically, if you could find the owner, you should necessarily maybe try to seek permission, but it's all about determining that piece too, and also like their kind of time frame too. But yes, we'll circle back to orphan works in a little bit. But good. And I should say, Heather, I think I had to rethink this question. So Heather asked, when it comes to orphan works, it's different. Yes. So technically, no. The intellectual rights are always separate from the physical ownership. Just because you've collected something and you can't necessarily find the original creator doesn't de facto mean you immediately own the copyright to that, is what I should say. So I wanted to come back to that. So let's talk a little bit about patents. I've got this lovely patent design from Apple for the original iPhone. So patents used to really be about physical things. But now patents are really more about designs, could also be a process. And design patents have gotten really, really complicated. And sometimes it even goes into trademarks a little bit too. There's been patent disputes over leggings and patterns on leggings in the not too distant past. There are sort of three types of patents. There's a utility patent, a design patent, and plants have patents. So you can actually patent seeds and other things like that. This has been the big kind of issue with companies like Monsanto suing farmers who are keeping back some amount of seed for seed cropping instead of buying the new seeds directly from the source. And there's been a lot of contention over that. Design patents, of course, like designs, like we see with the iPhone here. Utility patents can be kind of a lot of different things too. Trademarks and trade secrets. These are sort of interesting as they can essentially go on into perpetuity. And I think it's kind of important to know if you find yourself in a business archives or maybe even an organizational archives that has some sort of logo or trademarks in particular is that basically after you have been in existence for a while, usually in the 5th or 6th year um, of after that application, you have to prove that it's being used. And use can be in any kind of material. So this is where it's important for an organization to document that they're consistently using their trademark and or different forms of slogans, things like that. Trade secrets are kind of interesting. It's information that can be a lot of different things. You know, because I'm in Atlanta, I talk about like the secret formula to Coke. But this could be a formula, it could be a pattern, it could be a compilation, it could be a program, it could be a process, it could be a device. These sort of complement patents, but the thing is that they cannot be formally defined through an intellectual property process through the trademark office or the patent office or the copyright office. These may complement things because as soon as a patent is put in, it's actually made public, so you can read kind of what people are patenting. But these are considered forever secret unless they are independently discovered. And so, this is where you might heard of concepts such as corporate espionage, where they're trying to get people in to understand these trade secrets. And that's where organizations get in a lot of trouble. Google and the couple of Google and the other self-driving company and Uber, that's what it was. I think it was Google and Uber were in a contentious lawsuit over self-driving technology, and it was all about a trade secret thing because they were poaching different people, and somebody took their intellectual property that was considered a trade secret with them. A lot of this has been supported through the Defense of Trade Secrets Acts from 2016. Of course, let's move into what everybody wants to talk about is copyright. So I always usually talk about copyright as and explain in sort of the expression of ideas. This idea that an expression is something that's tangible. So we usually think of it as music, writings, performances can be copywritten. So the actual choreography, etc., is actually copyrightable and able to be defined and held on to that. The term of copyright is always complicated. I think every time I take a look at something, I go back to the Peter Hurdle chart, which I've got a link to that somewhere in just a bit, which shows it really depends on the work and when it was put in and whether it's was re-registered. We at the GPLS, specifically my department, we help a lot with newspaper digitization, and we use to the full extent of the copyright law when we see a newspaper, and if it wasn't properly re-registered, it is considered in the public domain, and we'll send it out for digitization and to make publicly available. So there are 6 exclusive rights that a creator gets when they own the copyright of something. So first and foremost, this is the right to reproduce. And reproduction can be anything, and it has been defined as lots of different ways, and this can even be in terms of digital reproductions too. A person can also create a derivative work, which is something that is based very closely on that original work. We oftentimes think of this, it could be movies, it could be theatrical performances, things like that, would often be considered derivative works. The creator also has the ability to distribute. So this means they can sell, rent, lease, or lend these works that they've created that they have this exclusive right to. When it comes to literary, musical, dramatic, or choreographed works, they also have the ability to perform publicly. And so this can also be like movie projections, things like that, public projections, things like that. And also in another exclusive right, a literary, musical, dramatic, and a choreographic work, pantomimes, pictographs, sculpture works, the creator has the ability to display. So performance and display, that's sort of some nudgy things. When we're talking about display is just have it kind of in the public view and for people to be able to see it. Perform I tend to think of along the line, of course, just like a theatrical production. But when we're thinking about movies, that's actually a performance of that movie by projecting it and running a movie. And with sound recordings, you also have the ability to digitally transmit stuff. So it's this idea of projecting things either across the radio, through streaming services, etc. So of course we have our major exemptions. So there are, Title 17, Section 107 is where fair use is defined in U.S. copyright law. So there's usually sort of a four-factor check of fair use. So it's the purpose and character of the use, nature of the work, amount to be used, and the effect on the market. There's also one other exemption for copyright, which is again in Section 17, but Section 108, which is the ability for libraries to make preservation and access copies of material. But the real major considerations is technically the library is not supposed to make more than 3 copies, and it should not have any impact on the market. And that's kind of important, I think, to think about there. So we are at our first break. And so I want to give everybody a question, and then we're going to kind of talk about this question when we come back from our break. So I want you to think about how all the structures, all the legal issues are impacting archives, and we're going to talk about that. And so we're going to take 5 minutes. All right, everybody, I hope you had a good quick stretch. And I do feel like I have been talking too much. So let's actually backtrack a little bit. So anybody spend a little time and want to share your thoughts about how this sort of complicated structure, different levels of intellectual property impact archives? Anybody want to unmute yourself, or do you want to kind of bump into the chat so and give us a few minutes to kind of talk through this? Don't be shy. It's a good time to talk. I know
Josh,
it's 8 in the morning.
can you hear me okay?
I can hear you perfectly fine.
Okay, so this is Matthew Peak here. I think a lot of copyright issues and the way it's changed, legacy archives. I worked in archives that was founded in the 1860s in Montana. I don't think we would have taken in stuff over different periods, especially after 1976, if knowing some of the changes in the records laws with what we took in, especially audiovisual recordings. One of the archives I was at has collected local copyrighted performance musician recordings because no one's saving them, and they're just providing access. They're duplicating it. They don't have the right to do it. They're doing it, and they charge for digitization or ripping off copies. And they justify it as no one's going to check, but that's not the law. So
agree completely. Audio, and we'll talk about audio in a second. Audio makes me nervous. I have done some audio digitization projects, and we could talk about them. Anybody else want to jump in and chat about some of your thoughts too? And I think it is great. I think a lot of us would have had some at least different perspectives on those materials that we've taken in. Yes, Dennis is absolutely right. We do have basically everything we have in our collections, for the most part, is covered by copyright.
Models.
Anybody else want to jump in?
Hi, everyone. I do see a question in the chat, and I know my name does not reflect this, but I am part of the PDC. So this is from Jay Shepard. Thank you so much. Coming from a commercial photography background, I tend to lean more towards being careful, but also the challenge of trying to balance being careful with the researcher's needs.
Yeah, that's a really, I think, good perspective. And I kind of want to sort of talk, we will kind of get to that sort of idea a little bit later, is like, how can we structure the conversations we have with both our donors and our researchers to basically provide as much use and ability as we possibly can. Now, I will say the one thing that's like super important for us as archivists, again, like I said in the very beginning, I'm not a lawyer. There's very possibility we have some trained lawyers who are archivists in here today, but we really cannot provide legal opinions to anybody. We can talk about the concept of fair use and allow them to make their own decisions, which I think is something to kind of walk somebody through. But I've always been super careful saying, I am not sure this. Yes, this could be a fair use, but you must make that own decision yourself. And also, don't do it in writing. That's a little shady, but it is better to have some of these conversations publicly, or I should say, in orally, so where it's really not like written down and could be brought back if somebody decided to come after you and see. Maybe like one or two more comments, and then we'll kind of move on.
If I may,
Yes.
so I'm actually a program officer with the National Archives, National Historical Publications and Records Commission.
Mhm.
And one of the things I see on a regular basis is archives applying who want to digitize and make publicly available on the web really important collections, but don't address what their policies are for intellectual property rights. And one of the ideas I keep coming back to is pushing fair use. If you're making the information available at an access level online, not at a publication quality, but an access quality, I don't see a problem publishing it.
Mhm.
Or actually, I shouldn't say publishing, because that means something very different in the context of the commission. With putting it on the web.
Yeah, we're going to kind of walk through some of these issues too. We have a moment to kind of do a policy kind of conversation a little bit later, so I'll pitch that down the road a little bit, Nancy. But I think that is one of the struggles, and kind of to center it where we're at right now, is that we do need to have these kind of careful policy considerations when we're talking about things. And I tend to agree, but it's on the idea that it's usually okay to put materials online. And I'm actually going to say publish materials, because even if the quality we put online is not high quality, we are in fact doing publication. And I think that's been kind of put through the law, some of the Google cases and the cases that the various mainly book publishers have put against groups like the Internet Archives, things like that. So anytime we put something online, I think I can safely say that is an act of publication, regardless of the quality. But we can make cases in other ways, and we'll kind of talk through that sort of idea of what we mean by fair use in a minute. Susan jumps in here and says that I'm at a high school. Our student public productions carefully follow copyright production rules. They tape productions for use in class. But if they give a copy of the archive, she's asking, should I accept it? I'm thinking about 20-year class reunions, playing bits or all of it. I think that's a really good conversation. I would say you definitely probably want to accept it, but you have to think about yourself. What are you going to do with it, and what's your sort of access mechanism? Because, plays, publications, audio materials are always really complex, but if you're not like dumping it on YouTube and giving access into other different kind of ways, you are probably 9 times out of 10 okay. And remember, there are always like exemptions. And actually, since you're talking about playing bits and pieces, since we are dealing with things, let's actually kind of transition and talk about our next section, which I called Morty the Moose, and their totally non-infringing journey, copyright realities and problems. And which is really sort of one of the reasons I wanted everybody to start thinking about kind of the realities of archives, is so we can start thinking about some of the kind of issues. And some of the issues aren't necessarily archival issues. I think more recent Supreme Court cases have really bore this out is with a digital environment, it feels like those exclusive rights are getting a little more exclusive, and it feels like even the owners can kind of claim almost near limitless, even though there are technically limits on the item. So I mean, of course, the rights extend to digital reproduction and the way you have to access that, which is usually dictated by some sort of licensing agreement. The idea that there's this sort of changes in sort of physicality, how we interact with intellectual property, and also performances and audio, things get even more complicated, and the sort of area of rights, which I know is what sort of Susan was kind of talking about. I also think too, when we talk about exclusive rights, these rights have kind of been corporatized, wherein more and more kind of authors are either selling out their rights or using kind of strict management companies to manage their rights. And oftentimes, if those rights are held by a major corporation, you are more likely to be impacted by their legal team than you would normally be. And then sort of another major issue with copyright, especially exclusive rights, is policing of that copyright has now become automated, whether it be through AIs or algorithms that are looking mostly for music more than anything online in the various platforms, but also the sort of the ability for people to make copyright claims very quickly, and oftentimes, I would say erroneously, is something that's really impacting depending upon the platform that you're using. Those kind of claims when someone does a copyright notice, or if someone doing is essentially using the Digital Millennium Copyright Act to say, I own this material and I believe that someone should take it down. The Copyright Office gives a template DCMA takedown request. On their website, you can see it here. So basically it says the person certifies they own the following works. The material blank, blank, blank infringes this. I'm saying this in good faith. And you give your name and electronic signature. A lot of platforms, and unfortunately, many of us are kind of, I won't say forced, but by virtue of whatever resources we have, we end up using free or lower cost platforms such as YouTube, some of the other video places, so various social media platforms kind of do this automated, and they don't necessarily have the resources to do what might be considered a full fair use check when someone goes through a process for when someone requests for something to be removed. Just kind of a note there. Also, too, of course, I mentioned earlier, this is being automated. YouTube, I think, is really notorious for this, specifically with music, and following kind of some of the stuff that goes on is a lot of those music bots, the ones that target videos on YouTube in particular, aren't very good. And, you know, this can flag accounts, this can cause all kinds of issues for people for what you've been doing and working on, and et cetera. So just sort of one of the sort of realities there. So when I talk about sort of the issues with sort of kind of modern, where we see it here, is that sometimes it feels like we are a little bit disadvantaged in terms of copyright. That means we may not be as sort of a power player and have that sort of ability, and in sort of the landscape, it seems like it's a little bit harder to kind of make things available without having that sort of existential crisis or, you know, constant worrying and consternation. I would say, and I actually think I need to kind of update some of these terms. I would say that the Digital Millennium Copyright Act has kind of been weaponized, and because of that, fair use isn't necessarily prioritized at the level that I think it should be. It's sometimes easier for those of us at education institutions or having educational missions, because we can make a really good fair use case because of educational requirements. Another thing too is because the landscape is so, I'm trying to think of the best word here. I don't want to call it like fraught, but so geared towards making sure you have maximal rights over intellectual property that when archives take material, I think there is either internal or to some extent, I think maybe even a professional push to always ask for as much power over intellectual property in order to protect ourselves as much as possible. And then I would also say that online platforms, especially ones we do not control, are not good spaces necessarily for archival materials to be accessible online because of just the nature of the systems that have been created to police copyright and other issues too. When we talk about audio rights, another sort of reality that I like to bring up is that there is a lot of different levels to audio rights. And this is the same thing too, kind of with performance rights. So if we talk about a song, someone might have arranged that song. And so may have come up with a specific way of the sound of that specific song. There also will be a producer. There will be a performer who is actually performing the music or the vocals. Like, so there could be multiple performers. It could be, you know, multiple vocal performers, multiple musical performers. There's also potentially a person who wrote the lyrics for the song, or maybe even the original composer could be credited and has rights to it. And if it's sort of more modern music that does a lot of sampling, you might have, you know, some random person from 1981 who has some amount of rights to it. And then, of course, it goes on and on and on and on and on. Oftentimes, these people own different percentages of these audio rights. And so that's why music and audio types of performances and visual performances to some extent are so much more complicated. So again, kind of what does this mean for audio is it's hard to justify fair use for audio. I'm just going to be honest when it comes to things. It's easier to justify, you know, photographs, textual materials, maps, things like that. But audio can be really tricky depending upon what the nature of the audio material is. Supposedly, the Music Modernization Act is going to create a system that will allow for basically getting permission, but that permission will come with a cost, and create a sort of centralized place where you can request those rights to put things online. Again, I just haven't seen it implemented a ton, and so we would probably want to reach out to someone who works exclusively with music archives to kind of talk through some of those issues. But there are bright spots. There is a lot of support for our kind of what I see as remix culture. Although I think we can maybe add this on as like commentary culture, because I think people were doing a lot of remixes sort of 5-6 years ago. Now it's more like people doing a lot of commentaries on things. And so the DMCA gives some exemptions for being able to do commentary, remixing, talking about things, specifically in videos online, and allows that as an exemption. And so there is encouragement for taking stuff, at least small parts, and being able to talk about it and kind of going about with sort of a transformative use, you know, going from, I'm not really just showing you this video of this thing, I'm actually talking over it and explaining it and adding value to this particular work here.
There is a question in the chat, Josh. How would you handle inherited oral history recordings?
So that is a really good one. Hopefully, I mean, I'm guessing these are inherited ones. That means you do not have an agreement. Presumably, Aaron. So correct. So, you know, I don't want to preempt one of my sort of big points that I like to make later but the big part about this is to go through and do a review. I sometimes think with oral history, if you can maybe try to find some of the people it would be best And again, this is where we talk about doing a good faith attempt to try to get permission. And then you can, and again, I hate getting kicked into the can, but I don't want to like preempt some of the big kind of conversations we'll have later. Is there are methods you can do where you will put statements online that allow people to request things to be pulled. One thing I would like to mention here, since we are talking about this, so we don't have to talk about it later, is that privacy, especially for things like oral history and some other written materials, kind of intersect a lot. We're not talking about privacy today, but one of the sort of core tenets of privacy, and sometimes I see this, especially with things like oral history and other materials put online, is that relatives of those people who are in some kind of item, in some sort of publication of archival materials, will often request things based off of their understanding of that person. The thing is they cannot request it based off privacy, because privacy of an individual ends at death. The person themselves would have to request it on their behalf. So if anybody's ever concerned about the sort of privacy, if you can determine that the parties involved in whatever material you're looking at are no longer with us, then there is no privacy concerns. Privacy is only for people who are still living. Quick note there. But handling inherited oral history recordings is something we can kind of, I think, chat through a little bit. I was able to speed us up a little bit here. So I do have the opportunity for a couple of quick commentaries on remix culture, but this idea of, from at least from people, like strict copyright control is not necessarily valued. Although if you see creators on like Etsy's, like patterning copyright is kind of valued. Remix culture itself does police non-attribution. There's really sort of a culture of people saying, if I take something from somebody, I'm going to attribute to them and send them in your direction. Sometimes cultural context is lost during the sort of remix. And then often BIPOC individuals have their content stolen by and not attributed. So there is both a push by a community who does a remix and commentary to attribute, but then there's also a lot of times people stealing content and not attributing that content as well. So right now, I want us to take a little bit of a break, and I want to take a slightly longer break this time. And so we're going to take about 15 minutes for everybody to kind of sit down and take some notes. Of course, walk around if you need to. I'm going to get some more water. But what I want you to do is do kind of a sort of really brief copyright assessment, and we'll kind of report out a little bit for this. And what we're going to talk about here during our break is, I want you to kind of go into your policies if you can, or if you can think about what your statements are, is can you identify current copyright policy? So do you have some sort of statement about copyright in your donation agreement? What do you say in either your research or reproduction agreement, or can you identify that? And also, do you have any statements kind of around publication? When we talk about copyright, oftentimes we talk about if our organization are risk averse or risk tolerant. Risk averse organizations are super worried about people suing them, and so they tend to only want to put materials online that are either exclusively in the public domain or they have rights to. Risk tolerant ones are ones that might make a little bit more of a fair use case and really think through some of these fair use ideas before putting those materials online. Also kind of want you to think about what might happen if you get sued. And we'll kind of also I'm trying to think of like Aaron's question by not completely preempting things we want to talk about later, but also maybe answer some parts of it too after I take a few minutes. So I want to take 15 minutes. So that would have us come back together at 10:30 your time, a little after 10:30, 11:30 my time. A little behind my schedule, but that's fine. So take a break. I'm going to turn my camera off think about your organizational environment for your donor agreements, reproduction agreements, any other things you have, and if you want to kind of share, and then I'll probably try to get on in a minute or two and kind of work through Aaron's question about how handling those inherited oral history questions without preempting some of the stuff we'll talk about later. All right. Good, everybody, I'm here, and if anybody has any questions for me, take about 10 more minutes to kind of think through some of these questions. Wanted to talk to kind of Aaron. I would make a consideration for, you know, how old the oral histories are, whether or not that you can get in touch with the individuals potentially, and maybe just see if you can get permissions just to be on the safe side. But then also I think you could make a fair use case to put them online. Specifically if you were going to go through that, and there's some other things we'll talk about later that you can do to kind of indemnify yourself to in case somebody does come back. I think with oral histories, and we're really not talking about this in terms of copyright today, I like to see really good agreements on those, especially ones that have informed consent. So legacy ones make me feel a little nervous. Of course, you can always put them online with some sort of access restriction, like someone has to sign in, they have to ask permission, or you only share them a link when they request it. So you can kind of not make them super public if you're really concerned. But I think that's also a privacy consideration about the content of them too. So sort of beyond copyright. Just wanted to put that out there. Alrighty, let's come back together. So anybody feel comfortable sharing? Like, were you able to identify your policies? Or do you think you are at a risk averse or a risk tolerant institution? Or do you feel like, what do you think might happen if you were sued? So anybody, feel free to chime in on any of these questions, and we'll spend 10 or so minutes, I think, talking about this. Don't be shy. I know for us at GPLS, since I work with our public libraries in the state, I do know I have given them a pretty good deed of gift that does talk about the various like copyright related issues, both reproduction and or digital access, those kind of things. Reproduction we haven't really talked about a lot. It's on my list of things to do. And we've had a lot of conversations about how we deal with things online, because specifically here in Georgia, since we share a lot of resources between our Galileo group, which runs our Digital Library of Georgia, which is kind of our main platform for providing access. We've had a lot of conversations. Nancy mentions most of the repositories they interact with are risk averse. I think that's going to be pretty common. Maybe if we focus on that, that might be an easier question. Do you feel, and if you want to throw this in the chat, do you feel like your organization is risk averse or risk tolerant? I'll admit I am extremely risk tolerant. And part of that is there have really been no suits against archives for copyright infringement. And I mean, I'm not talking about the Internet Archive and their recent book issue. That is actually something I think is kind of totally different. Although it's probably going to have reproductions in the archival world. But there have been no suits. Risk tolerant, so we have a one risk tolerant. Yeah, and I can see that too. We have a whole section talking about how to deal with your counsel and to hopefully educate them on your needs. And I've had both. I've had really non-understanding counsel, and then I've had really understanding counsel.
Hi, this is Dennis down in New Mexico. And and so I would say, I think probably like most archives, we're risk aware and risk cautious. I don't know I'd go so far as to say risk averse, but certainly cautious. So our deed of gift form does have a section that covers copyright and, whether the donor, as far as they know, controls the copyright for some of the material, for all of the material, or for none of the material. Often what I find in working with donors is they have no idea if they control copyright, and they don't really know what that means, which we wouldn't expect them to. And then based on that, are they going to transfer the copyright to us? Are they going to retain the copyright, et cetera? And then also on our use forms, and I think this is pretty standard in archives archives and libraries I've worked at, we have a permission to use form that certainly covers copyright and mentions copyright code, and that the user is responsible for complying with copyright code and holds our university harmless for any infringement. And so we require that form to be signed by users before we provide access to materials.
Yep, that's pretty standard for most everybody on use statements.
Yeah.
Anybody else? Thanks, Dennis. Anybody else want to jump in? And I should say it is okay to be at any level. You know, it's like, this is not like name and shame kind of situation. Like, we are all in complex organizations and we all have to exist regardless of if they're risk tolerant or risk averse. And hopefully that's kind of our conversations can help us think through how to become a little bit better, deal with some of these. Oh, Shannon, I saw your hand go up.
I was just going to add on to that. Before anybody signs into the reading room, they have to sign off that they, digitally, electronically, that they have read the reading room policies and they will follow them. Part of that is copyright, that they won't reproduce, publish, take photographs and then publish them. But people don't necessarily read that, which is, I guess sort of expected, but and then 30 seconds later, I tell them they can't have a pencil and they're surprised. So I know that they're not reading that, and I'm not sure how to quite handle that situation when they don't read it.
That is a really, really good question. I always like to kind of walk through things with people. I've always been a big fan of, just so you know, and kind of having those kind of conversations. But that is a really good, actually something probably need to integrate, I think, a little bit more another time to do that. But that's a really good point of our users not understanding. And I think that also kind of comes back to, especially if you're interacting with more younger users, if you're in a college situation dealing with the copyright doesn't always sync up. It's not something they always think about, and they don't think about those rights. They think about, I'm just using this and taking a picture and sharing it with people. They don't think about necessarily those copyright issues that keep some of us up at night. Maybe one or two more comments.
This is Dennis again. The question we all seem to be avoiding is, what would you do if you were sued?
I've not been sued, but I've gone through discovery. And basically, I did what I was told. That is what I did. Go ahead. I saw your hand go up.
Yeah, this is Matthew again. So a previous institution, and I can't say which one it was that I was at, had a private collection. I worked in a different collection in special collections as a manager, and the collection they had, we had since the 1910s, because we went back to 1903. And at the time, the family had deposited, and this was very popular, deposit or loan, but they used a museum logbook instead of any paperwork or formal ledger. And the terminology was vague. And then in the 60s, they physically donated the rest of it. There were no forms, but we had a card saying donated, so we could at least prove in court. And we went to court. It was a state level thing. The attorney general went to court, and the family only cared about it once they learned how valuable the half of the collection was that researchers for years had been using. So they got rights to it. We had to split up this collection. The valuable research component was gone, and it ended up getting split up and sold at auction. So yeah, that case was not publicly reported in the press.
Yeah, that's no fun. And yet, Phoenix is really, and that's one of the reasons I have a whole section of. It's really good to kind of become acquainted with. I would recommend become friends, like work friends with your legal counsel, because they can really help you out in a big jam. Anybody else? And if not, we will go ahead and jump into our next section, which don't know if I'll go through it particularly quickly, but I'm going to try to get us a little bit back on time. Technically, it's supposed to take 40 minutes, and I have 20 minutes to get us back on time, so we'll see what happens. So I wanted to kind of spend a little bit of time really walking through archival issues before we kind of do our 30-minute lunch break and then have some time for, open discussion, which I think we'll be able to get through in 20 minutes with no problem. So the reason I ask everybody to think through all these different things is that I really think we have to be on top of our policy statements, and also kind of some of the approaches we have to with some of the things we're doing. And a couple of things I want us to think about are reproduction fees, specifically, licensing / publication fees, access restrictions, and then sort of donor agreements, along with some of these sort of major issues. Let's first kind of walk through kind of my thoughts on kind of what I think is really important to have in your donor agreement. First and foremost is sort of this ability to do some kind of reproduction and having the donor acknowledge that reproduction may happen. We had a couple of commentaries about having that sort of acknowledgement of rights, maybe not necessarily transferring rights, but just acknowledgement of rights. And also this idea of getting some kind of publication rights. I'm a big fan of doing things that gives us a little bit of breathing room. And well, I will try to make a case a little later on, and to some extent probably now. I go back and forth about wanting full copyright transfer to the archives. I believe there are scenarios where that is valuable to the archives, but I also have some parts of my brain that get me very concerned, especially around community collections and community archives. And to me, sometimes we're getting full rights feels kind of extractive and feels like you're pulling value away from a community that may be, especially for our marginalized community. And I do not feel comfortable doing that a lot of times. So oftentimes I'm very pro like non-exclusive licensing in agreements that, if you can't get copyright, or if that's not something that this situation would require, that you get perpetual license to be able to do what you need to do and put materials online. That just kind of can help your donor agreement be better and be more flexible. Other things too that I think are super important to put as acknowledgements in the donor agreement is a discussion of what kind of preservation activities might happen. And this could be changing it from one format to another, letting someone know that that is something that might happen, letting people know that they're going to be accessed, and if it's going to be accessed digitally and potentially online. That's just something to just let the donor understand. And then also let them know that reproduction may happen, and the sort of scenarios that reproduction may happen. Another kind of issue when we think about problems, and I kind of talked about this in particular, is like, are we asking for too many rights? And I kind of alluded to this. And again, I have this sort of part of my brain that gets me very, very concerned that archives, especially in the environment where so much around collections, or so much around copyright, is really about monetizing that copyright, that I do not want the archive to necessarily be seen as this extractive organization taking rights from communities and individuals. Not that necessarily most community collections are going to lead to some form of monetization. I tend to think probably not, but I find that kind of worrisome, especially on individuals. And so if you don't remember the case against, oh, my brain is fried here, against Yale on the ancestor image of an African-American person and their ancestor trying to claim rights on it. that was sort of a long kind of legal issue and kind of related to that. And I kind of want to talk about cultural rights a little bit later. Another issue that I always want to know is like, does the donor have actually any intellectual rights to this material at all? And I think, especially in my environment I'm now in, where I'm working with public libraries, this is very oftentimes the case that the donor found something and they don't really have rights to it. And so we have to think about the ramifications when we're going to provide access to those materials and what the potential ramifications are going to be there. And then again, my other thing too is who's being left out of this conversation. Again, really trying to think about like third-party rights. Like you may be given a collection where there's multiple people who have created some form of intellectual content. Could be letters, could be things like that. They technically have the right to whatever they have written, even if it's just a letter, depending on the time period, of course. It could be in the public domain. I always say that this is an opportunity to think through, and if necessary, go seek out and potentially get these sort of rights. Things that I always kind of bring up when we're talking about sort of who's being left out of the conversation is, you know, if, say, an individual who was an anthropologist recorded some form of ceremony for an indigenous group, by copyright law, the person who made that recording really owns all the rights to it. And if we're presented with this material, then we're presented with an issue where legally we might be able to do what we want to with it if the creator gave us rights, but we have to start thinking about these ethical ramifications of, we are presenting with this content, we might legally can do it, but what are we going to do with it? I hadn't said it yet today, but usually I like to start off saying, you know, what is legally permissible may not always be ethical. What is ethical might not always be legally permissible. And this is sort of that kind of tug when we start talking about these issues with copyright and archives, I think. Another kind of issue I want to talk to about are access restrictions. And of course, this is all about dealing with limiting our risk. So if we're limiting access to physical access on site, there's really no copyright concerns we have, except for maybe potentially the reproduction, or if you limit that reproduction, then there's no concerns. Oftentimes restrictions really are related to the donor agreement and having to balance the need for the community to access versus, you know, the donor's perceived concerns on whatever that might be. And of course, it's partly related to PII and protecting personally identifiable information. That's another conversation when we talk about privacy. But when we think about these restrictions, especially if there's sort of this like nebulous copyright concern that I think a donor may have, is always going to impact research. And then I oftentimes think a donor perceives that the risk is far greater than the risk actually is, because they may be concerned about things that will probably never happen. Now, there are times when risk is a definite thing. And again, that really tends to relate more towards privacy issues, I think. And again, different conversation, different workshop when we talk about privacy. I do want to maybe make a bit of kind of a bit of a conversation with sort of like reproduction fees. And I have strong opinions on this, and I've gone through a lot of different waves on this, but you know, I think the intent typically when we charge for reproduction, whether it be physical copy or digital copies, is to recoup cost. You know, sometimes we are trying to sort of preserve our value of our collections, or at least there are some people who want to really limit the ability to do reproductions through cost or through kind of difficult procedures to get reproductions because they don't want multiple reproductions of their collections getting out there. And if done properly through proper forms and proper acknowledgement of copyright issues, that can completely and totally minimize the copyright issues that we might have to conform to. but there are, what I think, some problems with reproduction fees. So anytime you have a process where the archive has to do an intervention in the reproduction, meaning the archivist has to go scan something or make a photocopy, you are limiting access. It is a barrier to access and is a barrier to research. Also, cost is a consideration. Like part of that cost calculation is, are we actually doing a cost calculation based off of staff time, staff salary, and actually legitimately trying to reproduce, recoup, and recover cost of us making that reproduction? And if that's the case, are we overinflating what that cost is to actually make some kind of income? And I know some archives have used reproduction fees as a source of income to help them do certain work, but I do have questions on the sort of ethics of maintaining higher cost reproduction fees for that, because you are at some point going to limit somebody's access because you're charging too much. You're changing the way they could access and their ability to access based off of your reproduction fees. I would also say that if you get someone to properly acknowledge that if they make a reproduction on their own, that their reproduction is for research purposes and that they're indemnifying and you know, the archives, that our risk is pretty minimal about what we can do. And you know, I'll just kind of say this, I'm kind of a big fan of letting people use their cell phone to take reproductions. Partly because, and I'll give you some background, one of my very first jobs in high school was essentially a records clerk. And my first day at work, for 8 hours straight, I did nothing but make photocopies. So I am not a fan of making photocopies of things. Anything I can do to minimize my ability to have to stand in front of a copier, I will do. But I also think too that there's a way to teach our users about some of the risks they're creating, but also kind of allow them to do work so we can have more time to do other things. Putting the onus on the researcher minimizes risk, but also frees up staff time to do different work or more important work or even teaching work or different types of work we can do. And I think the consideration here is, you know, if you have to charge a fee, make sure that fee actually is recuperating an actual cost as well. Yeah, and Phoenix is saying specifically they tell and encourage people to use their phone cameras, no flash. I'm even sort of like pro, like I've had conversations where it's like, oh, we're going to make them put a label in it so they know where it came from. But you can always cut a label out. You can always cut a watermark out. There's all different things you can do. Like the amount of effort to try to minimize people's ability to reproduce things online, I think, is not worth it ultimately. So next up, I kind of wanted to spend just a bit on licensing and publication fees. And I'm not sure how many people have been in archives where you have had materials that are valuable to, especially like publishers, textbook publishers, other publishers like that, where you've had materials that you could actually license. These can be really good revenue streams. I have, you know, St. Martin Press, I used to work with them specifically on image reproduction or publication request for Flannery O'Connor images. And that brought in a considerable amount of money to our foundation account. Also, licensing and publication fees is an element of control. I say licensing and publication fees because I've seen this in some archives where something might be in the publication public domain, but they do charge kind of this higher resolution publishing fee or something along that line. When it's not like a full kind of copyright thing, it's a little kind of problematic. The licensing fee is when the archives owns, of course, the full copyright and has the ability to license it for certain purposes. Again, I kind of glibly say stick to textbook publishers because, of course, you want to get as much money out of them as humanly possible because they're grifting money from, college students every day. But there are some, I don't know, really weird problems about this that make me, again, there's that part of my brain where I'm not sure I feel comfortable doing some of this. And so, again, when we're charging these license publication fees, maybe we are really just charging kind of a more expensive reproduction fee. So instead of like a standard fee, we charge a fee for high resolution. I wonder about the ethical nature of if we should be profiting from this material. Now, you may say if you've purchased a collection, you might say, yeah, I'm definitely wanting to profit from this material. We paid money for it. I still get kind of squishy about this. Oftentimes I think about working with individuals, and because of the nature of the collections we were working with, we would make even people who did like presentations go through a process. And I'm like, this doesn't really make any sense for going through a whole permissions process for a presentation. Or you also think about those working with academic presses and making them go through a pretty arduous and not inexpensive request process for an academic publication. And very oftentimes, the person writing the book has to pay for those publication and licensing fees. And do I feel that it is okay to charge someone right out of a PhD program $100 so they can use an image in their dissertation that is being converted into a book? I don't know. I know they're only going to make like $12.50 off of that book. Is it reasonable for me to get $100 when they're not going to make a lot of money off it? Again, questions. And again, it starts creating barriers to the type of conversation people can have. Another thing too that I always say is that this idea of when we say exclusive rights, I really think, and especially if we as the archives are getting these exclusive rights and trying to take it away from the creator and having it as something we control, I think it's really promoting that sort of what I see as the modern system of copyright, which is really promoting profits over people. It's not really about the work. It's not about engaging with the work. It's not about having conversations with the work. It's really about making money from stuff. And by kind of thinking about those systems, we perpetuate and we become part of that system. Now, again, I said I have strong opinions about copyright. Please disagree with me. I am perfectly happy to be disagreed with as well. So those are some of the archival issues I have. Anybody want to make a comment or bring up a discussion or ask a question in our kind of 3 minutes before we kind of do our 30-minute lunch break? And again, I've kind of just hit you with some really big Josh opinions. And again, always happy to be disagreed with. But I do think we got to think about what we're doing and what we're trying to accomplish and who is impacted by our decisions that we make as archivists when we restrict access based off of cost.
And it looks like we have a comment, and I believe Matthew is the first name, if I'm remembering correctly. And it says, a lot of the reproduction and rights charges come from having physical prints of photographs made. As my previous photo archives had to maintain a photo lab with an actual darkroom, legacy archival practices.
Yeah, I saw that as an issue as well for some of those legacy collections. Like one thing I think a previous supervisor, they really want us to have a photo printer. I'm like, we don't need to do this. And actually one thing I did is I said, let's lower the cost of resolution, make people sign something that they're just getting this image for their own research purposes. And if they want to take it to Walmart to have a print made, they can take it to Walmart and have a print made. I'm being a little glib, like if they just want to get a lower quality print. But yes, I think that is definitely a legacy practice that we might want to reconsider, because I don't know necessarily what the value of that is. But I'm sure there's some who could argue that there is a value in being able to do that. But again, I fully acknowledge that my philosophy, especially when it comes to access, is the less I have to do directly for the user, the better for me, because I have other things I think could be prioritized that are collection related. Like if a user wants a digital image and I already have it digitized, here's the digital image. I'll give you a JPEG if you're putting it in a thing. Something I can mention too is like I rewrote our reproduction policy like 3 times when I was at Georgia College. And one time I rewrote it and I made it onerous because we had students coming in requesting like whole book chapters being copied from books. And 1, that's a massive copyright problem. 2, that meant we were having student workers standing in front of copiers for hours doing digital, copying for somebody who just didn't want to sit in the archive and read a book because we only had that was the only copy we had. So we kind of started limiting it and changing when people could do requests. And then we finally settled on, once we learned like our process for payment became so onerous that we just started giving a certain amount of copies to individuals for free, that had the ability to limit the amount of copies we had to make. So we weren't making copies of everything, but also just made the process a lot easier. There was no money being transacted. It made the researcher think about what they were going to request. I didn't quite win the cell phone fight before I moved on to different things, but I was going to really work hard on that cell phone fight at some point too. And of course, this is like over 10 years ago. Any other thoughts? Anything anybody wants to bring up? All right, not hearing anything. So I do want to allow us to be able to have some conversations while we take 30 minutes. And if you don't want to talk, that's fine. I'm going to probably step away for a few minutes. So this is probably a really good opportunity just to throw some ideas in the chat. But think about what we talked about the first sort of half of our workshop. What could you do to kind of improve your relationship to copyright? Where are you standing right now? And what might be good for you? So we're setting 30 minutes. So we'll come back just a little after 11:30 your time. And if you want to throw in some chat commentary, that would be great. But we will be back then at 12:30. So think about this, throw some chats out here, have a snack or get up and walk around, whatever makes the most sense for you. And we'll be back soon. Everyone, if anybody has any comments they want to make, we've got a few minutes and then we'll start back right at 12:30. We had a really sort of brief chat. Nancy mentioned that they are going to ask more questions of their applicants and grantees. Caitlin asked our legacy acquisition paperwork when present is being held to today's copyright expectations, which generally doesn't address or can't meet. The institution is pretty risk averse. What do you recommend as far as making digitization and uploading decisions? One of the recommendations I made is doing something called a fair use checklist, which we'll talk a little bit about later, basically documenting the decision-making process. Another thing is trying to get permissions, and I'll bring up an article that was written a number of years ago that kind of gets at this issue, is oftentimes permission research doesn't always, is not always successful, but it is something you can do, but it can be kind of expensive. And then Nancy mentioned that the NHPRC, a grantee, developed a workflow for getting permissions, and that's something that we might could look at as a model. Alrighty, let's come back together. We had a couple of comments and some light discussion over the break. I hope everybody enjoyed their kind of 30 minutes to at least decompress. Anybody have any commentary on the kind of questions I posed to it for our lunch? And I know 30 minutes really isn't a long lunch for anybody. But anybody have any commentary before we jump into our next section? We will go ahead and jump in. So, of course, I call this section Larry, the lawyer, has a big mad, dealing with kind of problematic counsel. But really, what I want us to think about here is how to prepare ourselves when we're talking with, especially risk-averse counsel, and how to kind of approach our conversations with them. And then we'll kind of go into some strategies and other things like that for dealing with copyright. So first and foremost, what does a lawyer do? A lawyer evaluates legal risk and what could be the potential damage to an organization. Now, sometimes that damage is reputational, or could be a lot of different other types of things. It could be that potential damage, but really what they're doing is doing a risk evaluation. Then they will provide the organization advice on limiting their risk, especially in terms of copyright. Sometimes that advice is going to be sort of very restrictive about what you can and can't do. But if you can kind of explain to them a situation, you can potentially get them to maybe change their mind a little bit. Of course, if you have counsel, ultimately what they'll do is defend or help, depending upon the situation you find themselves in, and can work through those kind of things. So when we're thinking about what our counsel does, what our lawyers do for us, we need to think about kind of how they typically approach a situation. So oftentimes the immediate reaction of counsel is just to be risk averse. It is easier to minimize that risk because it ultimately saves the institution money in the long run. Meaning you don't have to worry about it, you don't have to think about it. It's just, we're not doing it, so therefore we don't have to worry about it. Depending upon your organization, their understanding of law might not necessarily be on intellectual property law. So if you're at a university, university councils, especially the council that is local to that university, is going to be probably much more well-versed in student law. So things like FERPA, things like Title IX, and other kind of issues that might come up. Intellectual property law might not be something that they are super familiar with. Of course, also, if you're at a university, depending upon the size and the number of counsel that you have, they're going to be busy with other issues. Same way for the government organization. It's probably even going to be more difficult to get good advice from counsel if you're in a government organization too. Private might be slightly easier. Really just depends on the situation in that kind of context. If it's a smaller organization, it's very possible you do not have easy access to counsel. Maybe the organization has one on a retainer, but they, it's anytime you ask them a question, it will potentially cost resources, cost funds to get an answer to that question. So something to always keep in mind. Sometimes their default is no, especially if they don't understand, especially if it creates a less risky environment. They are just going to say, no, you shouldn't do that. What we really need to do is try to get them to say yes, or at least maybe. And I think part of that process is always kind of being ready to answer their questions. And so, like one of the sort of key tactics to working with people, especially, they always say this about working with supervisors, working with administration, is make sure you are on top of things before you go and talk to them. So do your research, come with a plan and approach that you would like to take. And then I always come with a draft policy document. And so this is really important because if you walk in there and say, oh, we want to put these things online, what do you think we should do? They're going to potentially get nervous. They're going to ask about rights. They're going to ask about permission. But if you walked in and walk through all the situations, like you've done your research on the collection, you've done your research which other institutions are doing of the same size, and you have your policy statements all written, say, this is this collection we want to put online. We've done this analysis. We've done this research. Here's our plan for this. Here's the statements we need to make online. Everybody else is doing this. Do you think this is good enough, or do you have some recommendations for adjustment? Makes your process a lot easier. So let's kind of talk about what we mean when we're talking about doing research. I kind of am a major advocate for everybody learning how to read both the law and important judicial precedents for everybody. You can sometimes, if you need to read breakdowns, I think the Copyright Office has really good breakdowns of all the major copyright related precedents that are out there. They're actually like a one-pager, and I've given you a link to a couple of them and some links to the overall site that has all the sort of precedents in it. Really great way to just kind of have an understanding from somebody who's sort of distilled a case into basically the basics. I also recommend reading law blogs, especially. I read SCOTUS blog kind of regularly. Right now it's kind of the quiet season yes, there's and SCOTUS blogs is a blog about the Supreme Court. Right now, they're in the middle of hearing different cases that have been added to their docket for this part of the year. So we really won't be seeing a lot of cases decided for a couple of months at least, or could potentially be longer. But it's doesn't mean that you can't find interesting things about that. And there's also various cases going on at the district levels too. I also recommend look at what the literature is saying. And this could be, you know, I know a lot of y'all are taking this course to try to get some, you know, some kind of basic ideas about copyright, but sometimes I think it's really good to look into the literature, both in library and archive. Sometimes there's some cross discussion. Also, I think education literature, especially if you're a university, can have some discussions about what you can kind of do in terms of fair use in particular on your materials. And then I think another thing too is you really want to also talk to your colleagues and talk to them about what they're doing, how their council reacted, if you're in a similar type of institution. That's why I think like having these conversations with our state level societies or regional societies is really important, because oftentimes the same issues that everybody has, they're having at a state level or a regional level. In Georgia in particular, since a lot of us who are archivists work for the state, we oftentimes have very, very similar problems, and we can often help each other with the pathways forward. Even with our local people and some of our other individuals, we can kind of give them advice too. So I find that's super helpful. One thing I always like to tell everybody is like to give them an anatomy of a court case. So I mentioned this one earlier in our presentation. Is usually a court case will have a few different elements when you first see it. If you pull it up on the my brain is not working, on the Supreme Court website or even any kind of federal court case, you will see the term in which it was decided. You'll see something called the syllabus, which usually is a rundown of all the important facts of the case, and then you will see a sort of title of the case. So in this case, you can see Allen. And then you can see decision date. So it was argued November 5th, and then the decision came out on the 23rd. As you can see, it's a long period of time between when something was argued and when something was decided. You can see kind of further pieces of evidence. Usually there's a note that says held, and this usually denotes what the actual decision is. And usually that can be several different lines and several different kind of deciding factors and points that are being made. So in this case, you can tell it held that Congress lacked the authority to take the state's immunity away from the copyright infringement suit. So it basically held that the states had an immunity from this copyright infringement suit. And then a few other pieces that I don't want to necessarily go into. And then, of course, more information about it. So for instance, there's always, especially if it's a Supreme Court decision, one of the justices gave that decision. In this case, it was Justice Kagan. But there is always a note about who joined in, or if there was some disagreement. So in this case, all the justices joined with Kagan, so they all signed on to that decision. It's set for Justice Thomas, who had a disagreement with the final paragraph of the decision and wrote a concurring opinion in part. And then Bayer had a concurring opinion that Ginsburg joined it. So it gets complicated. Just essentially, the takeaway here is most of the justices agreed with Kagan's logic and understanding of the case. Other people had some slightly different opinions, but they agreed with the overall outcome. And then, of course, there are footnotes, just like any other kind of writing. Supreme Court and any federal court decision or any court decision has footnotes in it that you can reference a bunch of different cases and how they use those cases to make a decision for this particular case. So next step is, of course, is always come with a plan. I really, really think that The part of that plan is to knowing what you're going to be asking for. And so is it policy review? I have worked in 2 different types of institutions, and I don't know how y'all feel about this. I have been in an institution where we always asked for forgiveness. So that meant we did things, maybe not without exactly express permission, but then we kind of explained ourselves later. And I've been in institutions where that was not really something we were supposed to do, where we needed to get permission for things first. Whenever you're asking these questions of council, stay on topic. You know, try to keep what your request is to a very narrow scope, or in the scope of what you need to have decided by this. So if you're coming in, for instance, writing institutional repository policy, specifically something for people putting materials in the institutional repository policy, stick to that. And then come back with another question about digitized materials. Don't try to make like an omnibus like online access and online donation policy all at once. Put it together in parts that make sense, so you're reviewing different things at different times that kind of require different outcomes. Always have a draft ready review. And I think this is probably more important than anything. Like, don't just walk in and ask what the council wants you to do. Now, there might be you might have some administrators who may say, well, you need to ask them how the language should be. I would really recommend always having a potential draft when you walk in and to talk to council. Like, know what a lot of other people are doing and use those policy documents to your best of your ability. Another thing you might want to do is think about where there will be problems and what your alternative could be to that problem. So you may be asking for X. So say we're saying, all right, we're going to use fair use to put everything online. But I know that I'm going to have a hard time making a fair use case for the audio materials. And here's my backup for the audio materials. Well, we won't put them online. We'll create a way to access them with a password, or we'll allow only on-campus access through some other kind of system. You can always have alternative plans and try to think through and do an exercise of what all of the potential problems might be with a particular solution that you're going for. And you may not think of everything, and that's okay. But I think it's helpful to have that exercise completed before you go talk to council. So when we talk about policy examples, borrow liberally. Like, if you can find policies examples online, look at the language they've used, probably been reviewed by somebody's council, and think about how that could be applied to your institution. Is a certain phrasing good? Is a certain approach good? Does it make sense to you? And just start adapting for those issues. Like, I can't stress enough, like, you don't need to sit down and try to think of all the legalese ways you could write something. Go look at 4 or 5 or minimum like 3 different versions of a type of policy you're trying to write, and write that and borrow the pieces that make sense, put them together, and then try to pull everything together into a cohesive document. And then you can take that out to be kind of reviewed and taken to your council. So when we talk about policies, and since we're here talking about how you talk to lawyers to be able to approve these policies, I think there's some really, really key policies that you want to have. And the ones that I think are super important to have are, you want to have things in your acquisition policies, and you want to denote, like, who owns copyright, how is that being transferred, how is that not being transferred, who has the ability to do reproduction and get permission to do the reproductions you need to do, get permission to do digital preservation work and access, even if it's physical materials, because even when you are digitizing physical materials, you have to do digital preservation work on those materials once they've been captured. Of course, you want to also have things related to if you're going to publish stuff. And this could mean, do you want the person who's requesting an image for a book to go to the donor and request that permission? Do you want to have the donor give you the ability to grant that permission? Just basically how permissioning is going to work. Of course, you want to have some kind of reproduction statement, even if you're allowing people to do phones. This could be in your, your sign-in documentation, your researcher application, whatever approach you use to doing that. but it should make a statement about copyright. And then it should also mention that anytime reproductions are made, it is for research purposes only, and some notation that, you know, the researcher assumes all risk for anything they might do beyond their research purposes for those copies. You should always have some copyright statements. I prefer rightstatements.org statements. Here in Georgia, especially with the Digital Library of Georgia, we just reference to rightstatements.org. But you should have a statement for in the public domain, owned by a third party, owned by the archives, and at least have one that mentions her unknown status. The great thing about using rightstatements.org, those are already written, and you can just reference people to them and borrow those exact language there, and you don't have to come up with your own statements. I also encourage you to create some kind of access statement that basically says, you know, by providing access specifically online, you're giving people access to these materials, and kind of note what people can and can't do with those materials, and kind of note that if they're capturing any information about them, but also more importantly, kind of that you're providing these for research purposes as well. And then the last note I want to make is you want to have a DMCA. For some reason, my brain always wants to do DCMA, but a Digital Millennium Copyright Takedown Notice. Now, what one of these are is a notice that says, you know, if you feel that you own this information, or I typically also would include a note about privacy issues, that people can have a formal process to request that material being removed. That's one of the good points about the Digital Millennium Copyright Act, is it gives this sort of, it gives the potential owners an easy way to request, but it kind of gives the publisher an out if somebody requests it as well. So any question before we jump into our next section? No hands? Okay. So let's talk real briefly about, if I were to talk about a sort of a liberal approach to doing, and when I liberal, I mean kind of like a risk-tolerant approach to fair use and kind of making fair use decisions. For me, I think sometimes it's always good to kind of do and think about different forms of licensing. So just a reminder, as we're talking about fair use, we want to talk about the sort of purpose and character of the use, the nature of the work, the amount and sustainability of the use. I'll talk about different licensing major. I'm like looking at two screens, like looking ahead to make sure I'm on track, and the effect on the market. And so we've got our 4 factors, and typically these are all looked at in tandem and used to kind of make a decision around whether or not the potential use is going to be fair use. So another potential thing we could use to help some of the work we do is that sort of limited exceptions for preservation. So this is if we were trying to do a reproduction on site, but not doing one for public consumption. It is always for preservation. You could use this to deposit it at somebody else or in the archive at another institution, and it has to be a limited number of copies. And you have to be able to find stuff that has, and there's nothing available at a fair commercial price. Also, copies cannot leave the premise. When we try to make a Section 108 case, I find that it's really problematic specifically. And I know sometimes we can think about this also for digital preservation, but the problem here is that typically Section 108 really only says we can do 3 copies. Modern digital preservation standards require 7 copies, you know, on the high side, so that's really violating the rule. Section 108 in particular hasn't been updated basically since a little bit in 98, but really since 76. So the terms and conditions by which a library or an archive, museum, or anybody could make reproductions based off this section really don't apply to the current technological systems that we have in place. There's been attempts to do updates, and like 3 different working groups, and nothing has come of any of that work. I say that mostly because more than likely our work around copyright is going to have to rely on fair use and thinking through fair use issues. Now, we can do copyright clearance, but the thing about copyright clearance is that it's really expensive. The process usually done for copyright clearance is you have to find the person who owns that copyright. You have to communicate with them, and you need to show a good faith effort of communicating with them. So you probably need to do multiple ways of communicating. So you want to do an email, you want to do a phone call, and you probably want to write a letter. That is all kind of resource intensive. Time, staff time, and if staff time is being taken away, that means they're not doing other activities. You may get people to respond, and more than likely, depending upon the nature of the collection, you will get people to respond who will usually be affirmative. More often than not, you will probably get no response, or have people confused, and it may just cause more problems than I think it's potentially worth. So basically, there's a very minimal return on investment. Depending upon the scenario and how many documents you're trying to, things you're trying to get licensed for, oftentimes it's better and more, I think affordable, and I don't want to use affordable, but it's better for the resources for the archives to make a fair use case. And then even with fair use, we can do some things that minimize our risk as much as possible. So part of making that fair use case is going through a fair use checklist. And when we talk about fair use checklist, we go through, of course, the purpose of our use, the nature of the work, the amount being used, and the effect that it's going to have on the market. There is no hard and fast way to do this. Technically, courts have to decide if something is fair use. We are doing this sort of work ahead of time in hopes that whatever we have done is going to be in favor of fair use. It must go through a court to actually make a, quote, fair use determination. That's probably not going to happen. There is, as again I said earlier, very few cases of archives being sued for putting materials online and making them available to researchers. And so typically what we say when we're doing these fair use checks is it's something is likelier to mean that this is a fair use, and something that is likelier to mean that this is not a fair use. So if the purpose of something we're doing is nonprofit, so for educational purposes, transformative, or something kind of creativity. Transformative usually means you have to take something and turn it into something completely different that's completely different than the original. Courts have kind of said digitization is actually transformative. I don't know how well that would hold up in court. That kind of held up in the Google versus the publishing organization's case, that their digitization in optical character recognition of stuff was transformative. So I tend to think at least digitization of analog materials is considered a transformative work to some extent. And then also if you do something like you're taking an image and turning it into something creative, that is more than likely fair use. Of course, if you have multiple of these things under the purpose of the use, that's going to make it a better fair use. If you're doing something for commercial purposes, so saying you are trying to get some kind of monetary value out of it, and you are making a book and you're going to sell the book, and you're publishing a bunch of things and you don't have copyright to everything, it's probably not going to come down on you as something you could claim under fair use. If you're not really doing something new and it's really just a full-scale reproduction that doesn't make it any better or any worse, is probably not a fair use. Now, if it is the nature of the work, if we are referencing something or something that is nonfiction and has, already been kind of published, we can probably claim a fair use case on it. What's likely or no is if something is fiction, especially if you're reproducing a lot of it, art, or something that was unpublished, it gets to be a little bit more complicated. Now, I'm not saying just because something's unpublished, we couldn't make a fair use case for it, but it is something to kind of keep in mind and to consider. Now, when we talk about amount, we're talking about the amount we're using. So if we're using a portion of a work, such as a sentence or two, a letter that might be in a collection, although we could probably make a conversation around that, but basically we're taking samples of it, or smaller bits of it, that's going to mean more in fair use. What's likely or no is that if it's a complete work, or if we're really just getting the entire work, the quote heart of the work, then it's probably likely or fair use. Not fair use, excuse me. Now, of course, you might be thinking to yourself, well, what about photos? Is it putting a photo online? That's like the whole work. The key here is that sort of when you start doing these fair use checklists is like you have enough like balancing kind of to the fair use side versus balancing you towards the not fair use side. And it's almost like a seesaw in some respects. The last part that you have to consider is what is it going to do to the market? So if what you do is put something online and it will not hurt the market, like it's not going to stop someone from being able to make money off of it, then that's fine. If you do put something online and potentially hurt the market, that's a possibility. So if we go back to our photo example here, if I put like a web quality JPEG online and just to show somebody a version of it, and that photographer is still around selling images, which this is probably not a best case, our low quality JPEG is probably a little closer to fair use because that JPEG is not going to necessarily hurt some of the market depending upon the nature of that. Although I think my photo example is not a really good example, but the example of if you put lower quality online, more than likely that's not going to hurt the market for the full work or potentially different versions of it depending upon the scenario. Again, you have to think about everything around a collection, like who's the creator, what kind of relationship does the organization have with that creator, are they in the market currently, and is there going to be a potential problem if you do something with them, like you make things available, and just sort of the nature of the work too. So taking this sort of fair use checklist, my kind of approach to having these conversations is I tend to want to say there's sort of the approach I would usually take and the way I usually page is I always lean towards fair use. I kind of start off from the thought process that more than likely my use is going to be fair use. Depending upon the scenario, depending upon what you're trying to do. One of the things, if you ever put materials online, document the decision-making process. Create a fair use checklist. Have this created, if it's a digital form or if it's an analog form, whatever it is, have it, file it, keep it with that collection or keep it with your documentation somehow, connect it into archive space, whatever you need to do in order to make this documentation. So if somebody comes back and say, well, here's how we made this decision. The other thing too is that if you have, again, Digital Millennium Copyright Act, again, my brain likes to do DCMA for some reason. If you have a takedown notice, that usually saves you. What takedown notices do is they give the user ability to request you remove stuff. And that gives you kind of a stopgap. So you can take things out of an online system, whatever that is, temporarily or permanently. Just because someone makes the request doesn't mean you have to honor their request, but you can take it down and then spend time reviewing their request. If you feel like you need to get counsel involved, you can get counsel involved. You may ultimately decide they have rights to it and will remove it. And then maybe you want to go back and ask them for license. Or maybe you determine they have no rights to it and you feel like you can push back. We had a question come in. I want to mention one other thing too, is like, if you do use systems that are online systems and social media systems, be willing to push back on some of these sort of issues that have been presented with you. And Matthew wrote, one collection we're having issues with my university's archives is a professional photographer's image collection. That's image they shot for university publications exclusively. They gave the negatives and prints to the marketing department with the restriction that the images could be used for any university publication, but if used for non-university publication or commercial, the photographer had to give permission. But he sees this as a work, Bythew sees this work for hire, and meaning the university owns photographs, the photographer can use photographs for promotional promotion portfolios. So I wish I would actually have thought about the work for hire issue before coming in, because I sometimes get this one muddled in my head. I believe that the standard now, and I could be very much wrong with this, is that the contract must directly state that what you are doing is work for hire. And if the contract does not state that that is work for hire, then the creator potentially can say they have copyright of whatever they took photos of or whatever they created. I could be wrong on that. I can't remember. I'm fairly certain you have to have like an affirmative statement of work for hire. And there is sort of a weird period where you didn't have to have it, but I can't remember it right now off the top of my head. So this issue that we're talking about, it's possible it could have been a work for hire. You really need to see that contract. And honestly, and here's the funny thing too, is that, I don't know if any of you have got like, faculty contract. Here in Georgia, at least, our faculty contracts that we've had, I don't have one currently because I'm not faculty anymore, actually had this sort of discussion of stuff that if we created it, that the university owned our content. So they basically said everything we did was work for hire, which kind of disagreed with. But yeah, it sort of was covering that basis there, is that I'm mostly certain, and maybe if I have time to do some thinking and some researching real quick, I can get a certain, but there has to be an affirmative note in whatever the contract. I think there's some scenarios where you don't have a contract where it could be considered a work for hire, but at least the best practice is always to have whose rights are in something in whatever contract that you're doing. But I think it has to be an affirmative statement that it's a work for hire. Work for hires can get really messy really fast. But you could potentially make the case, again, that would be one of those things you'd want to talk to counsel, like if they think they can make a case that it was a work for hire. A sort of an alternative example of this is I've tried to make the case that there were some materials in our collection that I felt were state materials funded by state resources that did not actually have copyright notices from the period where they were supposed to have copyright notices, that I therefore thought they were in the public domain. Never gonna get anybody to be willing to jump on that conversation with me, but that is sort of something to think about too. Really great comment, and we'll try to maybe think through that one in a little bit. When we are doing checklist, one thing I always want to make everybody aware of, I think almost every archives, except for maybe business and corporate archives, are educational institutions. Or you can make a case you're serving as some sort of educational function. I think that usually helps us when we're doing any kind of fair use case. That oftentimes supersedes a lot of other things. Now, it's not always going to automatically supersede everything. Just look at what's gone through with textbooks companies and course reserves and all the different things we have to do now for course reserve systems. But it does give you a lot of weight to the purpose of our use. The nature, things get a little bit trickier. Again, I think with text and images, if we go a little lower quality and not super high quality, that gives us some leg to stand on. But you can always make the decision about how you're going to allow access. I love to talk about the New York Public Library's image collection, which I think a lot of their images they own rights to, but they provide pretty high resolution images online. No, you don't have to sign in. You don't have to do nothing. You can just click and download and use the image as you would see fit. Now, many of those I think are public domain that they do that with, but that's something you want to ask yourself. Audio, video, dance are always going to be really, really, really hard. And because there's so many different layers to them, that you may have to think about what kind of access can you give that's restricted, that might not be just full publicly available. When we talk about amount, we can limit amount, but the really question is when you're trying to think about how much you're going to limit. Of course, you can limit that amount of line and only put some things, but that might be a function of resource availability, but something to consider. I do want to push back on that notion that we want people to physically come in the building, which I think we do. But limiting the amount you put online in a digital collection because you want people to come into the building is maybe not the best logical sense. There are other things you can do to encourage people to participate on site, but you want to ask yourself, what are those things and why are you bringing them on site, especially when there's an opportunity to present them stuff that they may get better use out of. Of course, too, even when we're doing digitization, as I've kind of mentioned, digitization is often considered transformative. And so therefore that gives you a little extra boost on the purpose of what you're doing. You're doing a transformative use. Oftentimes, educational can kind of trump amounts, except for maybe like published books and things that are still in copyright and textbooks. Don't mess with those. Again, there are exceptions. Authors' papers might be more problematic, especially if there's again, we had the example earlier about somebody found out something had monetary value. Anytime that there's monetary value, estates and people who potentially own that copyright get very litigious. Again, I think one of these things is is problematic with the nature of copyright now is that everything seems to have a dollar amount associated with it and is not necessarily related to that sort of promoting of promotion of new things and new ideas and new works. Don't put major motion pictures online, even if you have copies of them. You just don't do that. It's a bad idea. And of course, textbooks, which I already mentioned. When we talk about effect on the market, most archival activities is not going to affect a market whatsoever. You may have this issue with orphan works, kind of what we were talking about earlier. And I did look that up for orphan works. The term on orphan works, especially if it's unknown and you don't know when the author died, it's 120 years from the date of creation. So right now, things that are in 1904 are in the public domain and nothing after that. The same way goes for if it's unpublished, but you know the author, it's 70 years, life of the author plus 70 years, but unpublished are still considered in copyright. Those might have an effect on the market because they were never technically published, but you have to kind of think about like who is actually going to come out and publish this thing and what might be the potentiality of something like that happening. The other thing too is because we typically are not doing things for a for-profit purpose, that we're not going to be having really any kind of effect on the market. And you can mitigate some of these things by providing lower quality versions, access versions, things like that, in ways to kind of work through a lot of these kind of issues. So, any questions about fair use and fair use checklisting? Before we talk about sort of alternative frameworks. Go ahead.
Yeah, I have a question about oral histories, especially because I used to run a couple oral history programs for a stay in a company, but now I've got oral histories from students who did them as assignments for a history class, but they did them in the communities and they were done in the 70s, 80s. Some have release forms, some don't, but they're important history that's now not documented. And sometimes the students did papers that were graded and the professor kept the graded stuff, so it falls in FERPA. So like we have these interviews, we want to make them available, and we're wondering if we can risk assess that we could put them online, but how close to educational? It's how are we making that assessment of interviews that don't have formal paperwork or are done as part of a class? If it wasn't for the class, I would be more apt to put them online with a statement, but yeah.
I tend to think I think the class issue is not as big of a deal as you think. I think since you don't have the papers, I'm not so worried about the FERPA stuff. And also, sorry, I'm not in FERPA brain right now, but this might not necessarily, the interviews themselves might not necessarily be a FERPA issue.
Okay.
Because what is this going to tell you about the student? That they were at that university? That is a directory piece of information, which is admissible under FERPA without any kind of need to denote that. So we can push the FERPA issue, I think, aside. Although I think I need to think, you might want to think a little more about that because I might not be 100% on that.
Yeah. That's what we've gotten back from Department of Education, actually. I talked with 2 reps last year about not this, but another thing, and they laid out specifically for the archives what it was, and so we took notes, but that was the feedback but we weren't sure, because this was a class product, we weren't sure. Yeah, we weren't sure.
Yeah, I mean, it would be better if you had the agreements, and then I think you could go for it. I've done a project where we had a class product, but we had agreements for every single one that we did.
Yeah. And even some of those old agreements, they say it can be made available for scholarly purposes. I like that 1981 phrase. And I'm like, well, if we put them online for the general public, does that fall under scholarly purposes anymore?
Yeah, I mean, so personally, what I would say is I think you could make a fair use case.
Yeah.
Yeah. I would tend to think maybe FERPA doesn't apply, but I want to, this is like one of those things, I always go back and reread the regs. Every time I have one of these issues, like, okay, let me think through this so I can make a case for myself and document it. But the other thing too is then you want to have a good notice for people if they feel like they need to be taken down.
Okay.
I tend to worry more about privacy issues with oral histories than I do copyright. Mostly because I don't think people are going to I mean, and it can happen because people do, documentaries and things. There's not usually a market for oral history interviews. It's really about a research activity. And so I tend to say there's gonna probably be a fair use case.
Yeah.
But, and also like, then you want to have that kind of like, I think FERPA probably doesn't apply, but you can probably dig into it a little bit more and figure it out from there. I personally, I would think it would be okay. We talked about the work for hire. Any other questions? Are really great questions. All right, not hearing anything. So I want to talk about alternative frameworks, or Danny the Duck likes to share. Part of this section is really us getting into a couple of different licensing types, and thinking through some things about maybe where we're not really necessarily doing that sort of maximal rights kind of requirement. I know. And I think in many institutions, still the framework is certain institutions will not take something unless rights are being transferred. And again, I mentioned earlier, I have sort of ethical issues with that, especially in some scenarios. So I kind of want to talk through a few issues related to this and some alternative frameworks where we can kind of think about our licensing and think about how we can share it. Of course, Creative Commons is pretty much widely used. This is also really great for materials you may own the content of, and to kind of allow permissions for other people to remix, reuse within sort of certain parameters of things. It does allow for profit remixing, which you have to think of yourself for in your institution, in your institutional environment. What does that mean? Is that something you feel comfortable doing? I could think of a scenario where you're a university archives. Personally, I think university archives, especially if it's university creative things and you're a state level institution, that stuff's really public domain, but that's just me. If you put something online and said, hey, if you want to make stuff with this, go right ahead. Maybe people are making cups or, some other kind of Etsy product where they're reusing images that you've provided online. That could be an example of something you might feel comfortable with. Some people might not feel comfortable with that. Creative Commons gives us 6 different license types. And basically it is from the most permissive to sort of the least permissive. And so you can see, I don't want to read every single one of these, but basically each one allows for different types of reuse, remixing, redistribution, or even licensing for commercial use. Of course, the most strenuous one here, kind of at the bottom right corner, they can copy and distribute, but only for non-commercial purposes, and they must attribute. And that's sort of the great thing about Creative Commons, is it sort of encourages everybody to say, hey, this is the person who put this online and made it available, and you should go back and take a look at their stuff as well. So I think it's a really great system, especially if you're going to minimize the sort of interaction the archive has to do and minimize the staff time that's taken for the permission process, because doing permission work requires work. And if it's legal contracts, then that means you have to bring in legal people into it, lawyers into it, and everybody has to sign off on it, and there's a whole contracting kind of thing. And I don't know about your institutions, but it can take me 6 weeks to 3 months to get a contract signed. I think the longest I've been on one was 6 months. And it was a contract that had no money being shared. It was just a contract saying they're going to give us access to the software for free. So if you can get through something that means you do not have to have agreements signed with people as they're being signed and dealt with. When we talk about acquisition policies, I really want to encourage the ability to kind of share ownership or share the ability to share, kind of. Basically getting, if you have somebody who's famous, see if you can get them to agree for really liberal reproduction and access exemptions for their content. So meaning you can put things online, you can do different things with it, and then hopefully they won't think so much about how much they want to try to monetize their creative works. Might not always be possible, especially if you're in an institution that really is chasing after the sort of more well-known creators. Might be more difficult, but you could be surprised depending on, sometimes institutions don't think to just ask, and some people are very willing if you ask and explain the reason why you want to do this. I think it's really great to share ownership personally, and sharing ownership can look like a bunch of different things. This can be, you just get liberal reproduction policies and access policies and the ability to put things online and publication permissions, and maybe even handle permissions if other people want to publish for the author, or you can just have really good reproduction and online access policy, and allow that person to still kind of own something that they created. I think this is really important, especially if you're trying to document communities that have been underrepresented in archives, and more importantly, communities that might feel that their communities are fractured or being extracted out of. I mean, we are in this sort of period of, especially if you're in a metropolitan area where you have gentrification, which kind of changes the fabric of a lot of different communities. And I think and feel particularly strongly about this, that feels like an extractive enterprise when we're going in like, oh, there's all this community stuff. Let me get all of your creative rights, your intellectual property rights for this stuff so we can have it, and it just makes our life easier. Just feels super extractive to me, without sort of a return to that community and an acknowledgement of that community. I do think sort of an in-between like sort of sharing rights and kind of letting rights kind of go down through a family line is the idea to ask for rights to be transferred on death and to go ahead and have that signed in the agreement. I think that's perfectly acceptable. That does help eliminate some risk or your requirement to have to sort of maintain communications with an estate and descendants. So I think that's really important. I'm pretty adamant when we talk about oral histories and writing agreements for oral histories. And actually, one thing I would encourage all archives to do, if you're seeing professors do oral history projects on your campus, you write an agreement and you get all those professors to use your agreement. That's something I really pushed and made happen the last time I had to work with an oral history project on any kind of scale. Is to sort of share ownership. So basically the archives gets the right, the ability to reproduce, but the narrator and the interviewer maintain sort of rights to their own words. I feel, and again, this is sort of a feeling thing, it sort of acknowledges what that person is doing by giving their story and telling them that their story is valuable to them. We're not trying to take their story from them. Also, another thing too, while we're really not here to talk about this, informed consent should be a part of any kind of oral history program. Don't have time to talk about informed consent because we're really just here to talk about copyright, but informed consent should be related to that piece as well. Another thing too is we just have to get in the habit of talking to people who are creating materials and explain why we have to be able to share this and why it has to be able to go online and why it's so vital to let our communities kind of interact with stuff and also have the ability to do things with the content they find and to work with it, investigate it, and play with it, and have conversations with it in different kind of mediums and formats. When it comes to access, I oftentimes want us to think about the widest possible spectrum. You know, I am a sort of a digital humanities person too, in addition to all the other weird things I get myself into. And access really has become needed to be more than just, oh, I need this picture. Sometimes I need this picture in a really high format because I'm going to run it through some machine learning process to identify people's faces. And if I don't have a high resolution format, that's not going to work very well for me. And so the access we need to think about are things like not just physical, but extremely technical access. And this is super, 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 super important for native-born digital materials because a lot of the research dealing with native-born digital materials requires pretty technical access to those materials. I've mentioned, of course, Google versus American Writing Association several times. That sort of told us that digitization is considered transformative work. Another thing about access policies, especially if you can provide things in formats, even if it's small video clips, it lets students and other researchers just go nuts with it. One of my favorite activities we ever did when I was at Georgia College is that we would have students make posters for different events or collections for us. They were a marketing class that were learning how to do Photoshop and photo editing, and one of their big projects was to create a poster for something. And so we would just basically give them like, here is a bunch of photographs. Here's the projects we need to have done. Go nuts. And they would remix, they would rework, they would retake, they would adjust, they would change colors, they would come up with different things. And it was just the best time ever. And it's because we kind of embraced like, my philosophy here isn't I'm going to just tell you you can only use this image in this historical context. I'm like, I want you to use this image because you're learning how to do marketing and I need a poster for this exhibit in our exhibit case. And typically the best ones would win and we would print them. And I think we even got to where we were printing all the posters for the students because we had a decent enough copier that had color printing, but it worked fine. And other thing too, and kind of sort of riffing on some privacy issues, which I find we have to talk about sometimes with copyright, is that it's okay if we have to make something inaccessible when there is a potential to cause harm to another individual. And this is where and that harm, you might want to have some conversations of what you mean by harm, but it's something to really kind of keep in mind and kind of sort of transition a little bit when we talk about harm. One thing I really do like to have a conversation about, even though there's not exactly a legal precedent for this idea, is this idea of cultural property rights. And what we mean by cultural property rights kind of initially comes to us from the United Nations, which was the Declaration of Rights of Indigenous People from 2007, which is basically saying that the idea of depriving people of this integrity of their distinct cultures and cultural values and cultural identities, as well as sort of the idea that Indigenous people have the right to maintain, protect, develop past and present, future manifestations, so documenting their own culture through a lot of different things. So we should basically acknowledge their cultural rights to these materials. While this is a UN declaration, guess what? The United States didn't sign off on it. So it sort of has limited bearing from a legal sense to us, but it is a framework I think is important to think about, not just for Indigenous communities, but I kind of think about this as for all communities, as well as, hey, maybe like if there's a certain community nature of this, maybe we need to be acknowledging other people's rights to express this community in ways that they understand their community, not the way we understand their community. And so kind of to that end, yes, there's a few legal frameworks for the US when we talk about Indigenous populations. Of course, there's the Indian Arts and Crafts Board, Department of the Interior, so that's just for products. We have the Indian Civil Rights Acts, and then we also have the Native American Graves and Repatriation Acts, which is really directed more towards cultural items and human remains. But I think the kind of key things when we're talking about this, I think it's good just to help us think through these sort of cultural issues. And while we may not have a strict policy statement, we want to think about how we involve the creators, the groups that create things in that sort of process of ownership. And so, of course, for those who might not know, we can usually define cultural groups as 4 different types. The 4 different types are like nationalities or regions, religions, race and ethnicities, and then associations. So these are things that have like long histories, fraternities or sororities, unions, groups that just sort of have their own sort of distinct culture that might require people from that culture to intervene in the understanding and the kind of ownership of that culture. So I always like to ask when we're talking about or talk about when we define things like cultural and heritage. Personally, heritage always gives me a sensation, especially being from the Deep South, because I think this term is oftentimes misused, especially in Georgia. But typically when we talk about heritage, we talk about this as the idea as this sort of a tangible culture that somebody has. There's also the heritage is that intangible culture, things that we don't always see and understand. And then of course, the natural sort of heritage and connectionship with natural heritage and spaces and places. When we talk about culture in general, the thing about culture is it's always sort of abstract. It's not necessarily something easy to just simply define. Most of it is things people learn and their learned behaviors and patterns and perspectives on things. There are also attitudes, so attitudes and ways people relate to events and life and situations. There's, of course, certain values that are culturally significant, knowledge that is divine to that certain culture, and then, of course, various material objects that might relate to that culture, and then things that are shared among a group of people. So I always ask is, and I kind of hinted at this concept a little bit earlier, is sort of who owns something. And I always say that copyright tends to value the creator. And again, copyright tend to be something that is specifically set up to focus on monetizing some kind of resource. And so therefore, someone who makes the recording is probably the one who owns the recording. And kind of examples here, of course, is, of course, recordings that are fixed, might be photographs, might be descriptions. People may have been participating in these sort of recordings by voluntary, or they might not have been informed, or might not have been given full consent on things. And the things is these document sort of specific cultural activities that have relevance to specific groups that then sort of implies that, well, because copyright law says this one thing, now this other person has full and complete control over and full and complete say over it without allowing that specific community or culture to have some sort of say in it. So I bring this up to also kind of say that if we think about cultural property rights and sort of, again, kind of putting the pitch in for shared ownership here a little bit, is there are some parallels. I tend to think we do have like that sort of idea of copyright, and I would actually say copyright, trade names, trade secrets, kind of work in our favor, because if we think of culture as sort of like trade secrets, it's like until people reproduce it, it should be kind of sacred and held. I think we can make a case. It might be a hard case to make for some issues. Now, I will say one of the intellectual properties kind of caveats here is that in the US, IP can't be held by a collective. Granted, it can be held by a corporation, but a corporation is considered a person, so not a collective. And intellectual property is for a limited time. When we talk about kind of cultural rights, there tends to not be a discussion of ending that sort of right to that specific cultural artifact, product, document of that culture. So we do have some points where the Western legal parallels kind of fail us a little bit. I would say there's a lot of parallels to privacy when we talk about cultural property rights. Partly this idea of basically disclosing things is considered private, or disturbing someone's right to be left alone, or this idea of appropriating something for our own personal benefit, I think really frames into that. And so kind of to sum up with sort of this discussion of archives and cultural property rights, is just acknowledge that we may have full control, copyright, intellectual property rights, everything of material that other peoples may believe they should have some control over. And kind of familiarize yourself, become understanding and sensitive, begin dialogues with your communities where this might be a case. I think it's also good to make sort of a balanced decision about how you're going to provide access and who you might need to communicate with to provide access in context. And then, of course, be prepared for any kind of objections that might happen and how you're going to handle that. Really, for the most part, what I'm kind of advocating for is having better communications with kind of all community groups and thinking about what the archives is trying to take and why it's trying to take it from these specific groups. I'm gonna skip those questions. I've mentioned this a few times when we're talking about oral history, but I think it's sort of important too, even for doing agreements with donors, whether it be for collections or oral histories, is this kind of idea of informed consent, is document that you talk to someone about the potential risk, talk about how you protect data, talk about the rights of the person, and what you mean for what is the purpose for this material to be available. Now, research purpose is always going to be nebulous in an archive because we can't determine every possible research activity someone might do, but we want to have a conversation about that with our donors. And I think it's just basically preparing everybody, educating them, having them understand. And I understand there's only so much time in a day, and you may not be able to have this conversation with everyone, but trying to think through, at least on a small scale, how you can have these kind of conversations about what it means to put something in an archive and what it means to let other people access the material. And of course, gonna skip this because I don't feel like we have enough time to really talk about the idea of local context, which is a really great, specifically with the traditional knowledge labels, for accessing materials, and kind of gives some control and ownership over the sort of processes through which people have access to. But I wanted to skip into and let us have at least a good 15 minutes to work through a case study. And so I am going to pull this up on the screen and then share a link with everybody. Actually, I think it probably got off of that. But I want you to take, say, about 15 minutes, read the case study, and then answer the questions, you kind of yourself. And then we'll kind of come back and talk about this case study. Okay, good. I am sharing the right screen. And so this case study is called Beam It Up Archivist. And it's basically you are at an institution and you're being mandated to put everything online. And what are you going to do? How are you going to go about that? What is, and a couple scenarios about where you may have some materials and material issues here too. So again, let's take 15 minutes. So that'll be 12:50. It's not quite 15 minutes now. And we'll come back together and talk, and then we can have a few minutes for questions too after that. So 15 minutes, read the case study, think about it, and then we'll come back together. And then I am going to turn my camera off for a moment. And I'll be back. I'll be sitting around here a little bit. Yes, go ahead.
Yeah, hey, so I was going to talk about the politicians one, because I've actually had this. I processed a U.S. congressman's collection in Ohio, and he was involved, and his foundation was involved with us, and we had this very thing. Our rule of thumb was we will put stuff online if it has to do with public policy decision making. So correspondence between Congress people. We would put constituent correspondence online because they're sending it to a public official. They have no expectation, because they're going to use these letters in speeches and talk. They have no expectation of privacy if they're sending that. But we wouldn't put them up if they had contents like medical stuff. Oh, I have cancer. Oh, my veteran benefits. Oh, here's my social security number. The Social Security office did my thing. We wouldn't put that stuff online. And the constituent, the financial donors, we wouldn't put that online. You'd make it available. You know, if a journalist comes in, researches, uses it, publishes it, that's one thing. But we have a connection with the congressperson and their foundation and their specialty agreements. So we're doing it if it has public policy. That's kind of our rule of thumb.
Yeah, that makes perfect sense. I always like to bring up the Maggie Dickinson article, which is about the Thomas Watson papers, which has kind of got some of the similar issues that sort of present in there, but that's a good one to kind of talk about the same kind of ideas. That's a really
Well,
good
I'll tell you, in that collection I worked on, there were photographs of the congressman who was under a House ethics investigation, which is why he didn't run for re-election. He retired instead. But it was with a Secretary of State getting a gift that we had in the collection that went over the federal limit for politicians being allowed to take. And we had receipts from the meal showing that another state or a country paid for the dinner at that event. So like, we asked, how much do we describe this stuff? Because then we get this person who we have an agreement with in legal trouble. So, you know, we decided we'll describe it, but we don't, it's not our responsibility to describe to that level if we put it online.
Yeah, that's great. We have a comment in the chat. Ada says, does providing access points such as an item level finding aid count as getting it up online? That would be the conversation you would want to have to an administrator. Does that, like, I mean, I appreciate like working within like the parameters that you're given and say, well, I've got the information up, I just don't have all the items up. If you think you can get away with that, get away with it. But it's a really good point there too. Anybody else, since we're back in time, have any other questions? Or any of these other ones that you want to address? And so of course it's like, how would you approach to making decisions? How thorough of a copyright search? And how would you mitigate risk? If anybody wants to chime in. And there's the dog. One thing too, I think some of these are really fun. Of course, I think the ones that's probably the most complicated is the ones that have music in it. And I think honestly that is really problematic. Maybe the classical ones you might get away with, depending upon if they were historic arrangements. But if they're modern arrangements of classical music, then that gets even more kind of complicated. Of course, we talked about the politician. There is the one collection where you probably have copyright, but you're in the middle of a probate issue where there's contested issues in probate.
There is a question in the chat, Josh. Do performers also have rights in music recordings?
Yes. Dennis, that is absolutely correct. So again, like it would be if it's a local music group, are they getting everybody to agree to being recorded before they record them? They would have to really get that ability. But the thing that I found too is sort of one of the collections I previously worked with was like all state band and all state chorus. And the people who were children at the time really just want to hear themselves again. So typically so I think you end up with this issue is, yes, the performers have rights, but they're probably not going to access their rights is what I'm kind of trying to say. And I bring that up is they just want to hear themselves. Again, Kathleen brings up a really good, if a publisher is out of business and there was no successor, does everything still apply? I mean, technically there's a possibility there is still a successor. It just depends on how the business was dissolved. Their rights just don't vanish. Again, this would be one of those things where you'd have to do really due diligence. And I still would not say de facto that it's in the public domain until the like actual time period for it to be in the public domain goes past. So like, just because you can't obviously see that there's a successor, there's a possibility that there's a successor. So like if a business goes out of business, it was a sole proprietorship, but they had children. Theoretically, the rights to that business unless it was sold to somebody else, would pass to the children, even if it's no longer practicing. Those rights still, I mean, there's plenty of companies that no longer technically exist, but all of their intellectual property was sold to somebody. That the intellectual property still continues. Theoretically, somebody could have rights to it. It's better to assume somebody has rights to it than assume that the rights are voided. Quick question. Any other commentary on the case study? I did want to like make sure we had just open questions. Doesn't mean anything if it's discarded in the trash. It's, again, you only we had a comment that says, what if items are found discarded in the trash? Doesn't mean anything. You have only gained physical ownership of it. Just because somebody threw it away does not mean they intellectually disavowed themselves of something. Unless they wrote on a note, I give up, I put all of this into the public domain. Like, unless they expressly say, I gave up all my intellectual ownership to this. Like, it does not matter. They are two separate concepts. Like, you know, that's why copyright can be one of those things that just makes your head explode a little bit. But like, it seems like, oh, well, this thing I found and I bought from eBay or something like that. I bought a diary from eBay that somebody sold. That doesn't mean that I own the intellectual property of it. I own the physical item. The intellectual property still needs to be determined. And who owns that potential intellectual property? Is it the creator? Are they still alive and didn't know that this thing had been, you know, purchased and found? Or is it descendants of the creator that potentially could have rights to it?
And there's Shannon's question. Has anyone used a takedown notice, and did reviewing the complaints become a burden? How much time does a review take?
It depends. I don't know of any research where anybody's really gone in depth into takedown notices. You know, it depends on how you policy, deal with it from a policy standpoint. So for instance, one of the collections we work with our public libraries a lot, and they find this is a really good community projects, is doing funeral program digitization. And specifically for our African American communities in a bunch of our kind of major cities, this has become an invaluable local history and genealogical resource. And so typically our policy for those is, if someone who is a descendant of that says, hey, I don't really feel comfortable with this being online, we just restrict it for a few years. And that's the review process. It's like, okay, we're able to determine this is correct. This is definitely somebody. We'll take it down and then re-upload it at some point in a later date. But you could have a whole other process. Some organizations do committee review. I have not heard of anybody, and it's very possible somebody's done this, I'm just not familiar with it, talk about how much of a review process they do and how onerous it gets. I would imagine most places don't get a lot of takedown notices. The only time you're going to really get a takedown notice is if you put something online that, and this has happened to some people, that Getty claims copyright ownership of, and Getty claims copyright ownership of a lot of things they don't actually own. Something from someone who is a major public figure, and that can be, a variety of different things, or potentially something that has some kind of controversy in your community. That's where I think you might have those issues. But more than likely, with the majority of the materials we're really working with, you are not going to see anything. Excellent. Anybody else have any more things? Unfortunately, I cannot stay on long past 2. Because I got called into another call, but I'm happy, of course, to answer questions. My work email. If anybody just needs to reach out to me, I have a few sample documents. I don't think any of them are perfect, that I can share. And I think I do have a DMCA takedown notice that I could share too. Although a couple of things I've written on like privacy and take down notices, if you ever purchase the Handbook of Archival Practices, or if you can get a copy of that, they're in there too. So just pull them from there. Awesome. Well, glad to be here. And I guess that's all. I'll stop sharing.
Yeah, I just wanted to say thanks, Josh, and thanks for everyone who's attended today. And we will have this recording out. We have to do a little bit of processing for it, but it will be on YouTube at some point in the future.